start this way, my favorite part.
Alors,
So this is the fifth meeting of the Special Joint Committee on the Declaration of Emergency pursuant to the Senate and House of Commons orders. Today's meeting is going to be happening in a hybrid format. With respect to health and safety matters, I'd like to thank everyone for respecting the recommendations of the health authorities and the Board of Internal Economy. If there are any technical issues, please advise me so that we can suspend the meeting so all members can fully take part in the meeting. I would like to also mention that there are interpretation services. I would urge you to click on the globe icon at the bottom of your screen. For the first part of this meeting, the Minister of Public Safety will be testifying, and the Minister of Justice and Attorney General of Canada will be here for the second half of the meeting. I'd like to remind the ministers that your representatives have been asked to arrive at a later date, but we would ask that you answer questions that are posed to you at the end of the meeting. The committee will have to discuss future business as to next week's meeting. I'd like to welcome the Minister for Public Safety and his associates. You have 5 minutes for your preliminary remarks. Thank you very much. And you have the floor.
Merci, Monsieur le Président. Thank you all for having me here today. And before I move to my remarks, I would just note that I'm joined by a number of officials, including my Deputy Minister, Rob Stewart. We have the Commissioner of the RCMP, Brenda Lucky. We have the Director of CSIS, David Vignon. And we have from the CBSA, Ted Gallivan. I'm grateful for this committee's work examining the events last January and February which led to the invocation of the Emergencies Act. The government's decision was precipitated by a series of unprecedented and simultaneous public order emergencies across the country. The images are seared into our memories. Let us begin by recalling the facts. At the end of January 2022, members of the so-called Freedom Convoy demanded that all vaccine mandates be revoked, failing which the Governor-General should unilaterally remove the Prime Minister from office. Others incited the violent overthrow of the government, with one threatening, and I quote, "The only way that this is going to be solved is with bullets." These ideologically extreme goals helped incite thousands to form massive blockades at our borders, legislatures, monuments, and here in Ottawa in front of Parliament Hill. The impacts were devastating. The daily cost to the economy at each of these ports of entry were astronomical. I would highlight that in Windsor, where Ambassador Bridge is located, we lost about $390 million a day in trade. Plants were closed. Workers were laid off. The manufacturing sector was stalled. In
our country, our ability to import and move furniture, essential medical supplies, food, and fuel to Canadians was compromised. Our closest friend and ally, the United States, expressed their preoccupation at the highest levels of government. And here in Ottawa, residents were under siege for weeks.
Was shut down. Small businesses were shuttered. People could not get to work or take their children to school. 911 here was flooded with calls, putting at risk people in distress requiring first responders assistance. And the seat of the federal government here on Wellington Street was completely overrun by blockaders who entrenched themselves with structures and propane tanks, who parked a crane in front of the Prime Minister's office and Privy Council office, and who repeatedly intimidated and harassed residents 24/7, making it unbearable and unsafe. When police repeatedly told the blockaders to go home, using their authorities to keep the peace, they were swarmed and threatened. When media tried to report what was going on, they were pushed and spit at. By any sensible definition, this was a massive illegal occupation in Ottawa for nearly a month. The government remained engaged with law enforcement throughout to ensure that they had the support and the resources they needed. However, when efforts using existing authorities proved ineffective, the advice we received was to invoke the Emergencies Act. At all times, we were guided by a simple principle of limited use. Put simply, when it came to the Emergencies Act, we were reluctant to invoke and eager to revoke. And on that note, I want to express my profound gratitude to all members of law enforcement who carried out their responsibilities with restraint and professionalism. They were able to restore public safety with minimal injuries and no loss of life, which takes us to this exercise. We welcome the committee's insights, not just what happened, but how to ensure that it does not happen again. We should carefully question the utilization of the Emergencies Act. Why? Because such authority should be granted only when it is absolutely necessary and strictly for the purposes of addressing a specific state of emergency. Colleagues, as parliamentarians, we have a sworn duty to uphold the law, for we are a nation of laws. To uphold the principles and values guaranteed by the Charter, we must defend freedom of speech, assembly, and lawful protest. However, freedom in a democracy never includes the freedom or license to trample on the rights of others, or small business families hoping to put food on their families' tables, or parents attempting to walk their children to school. And we should never, ever encourage or countenance or be complicit in illegal behavior, for it is an affront to the administration of justice and the rule of law. Surely on that point, we can all be agreed. I can hardly think of anything more important at this moment in our country's democratic life. I welcome the committee's work and your questions. Merci beaucoup.
Merci, Monsieur le Ministre.
Thank you, Minister.
Pour la première ronde de...
For the first round, Mr. Mutz, you have 5 minutes.
Thank you very much, Chair, and thank you, Minister Mendocino, for being here. I'm always intrigued by the perspective of others when it comes to activities and how those perspectives are different by many of us. And my view of what you described is different than yours. But I would ask you a couple questions, Minister. Do you think Canadians should be able to know why you and your government invoked the Emergencies Act? Because right now, Canadians simply don't know why.
The short answer is yes, I do. And the exercise that I'm here to engage with you, Mr. Motz and others, is to ensure that there is transparency as to the reasons and the events which led to the invocation of the Act. We published, if I could just finish one last quick word.
That's perfect. That's
I was
all
just going to say we published an essential backgrounder which laid out the reasons for that.
Thank you. I'm glad you added that or indicated that you want to be transparent with the Canadian public, because based on the stonewalling that's happened in the legal proceedings in court from last week, it would appear as if that may be a position that you're taking now as a government. And I would hope that, if you had good reason, which you say you did, to invoke the Emergencies Act, that you would undertake to share the reasons and the documents and the information that you relied on as a minister and as government, to share those with the Canadian public as to why you made that decision. And I would hope that you would undertake to do that, Minister, for the sake of Canadians, because we're not here for us. We're here for Canadians, to be transparent and accountable to them. And I would hope that you would, and would you undertake to release all the documents to this committee that we can rely on, that you relied on, that your government relied on to invoke the Emergencies Act?
Mr. Motz, I want to assure you that we are here to shine a light on the events which led to the invocation of the Act, which included, among other things, the blockades at ports of entry, which completely disrupted our economy, which put people laid off, which shut down businesses, which cost the economy millions, and frankly here in Ottawa, which laid siege to a community where no one felt safe for weeks. So I understand you may have a different perspective, but I would hope that you don't have a different point of view with regards to the facts, and those are the facts.
I take that as a yes, that you will be undertaking to release all the information you used to rely upon. You know, it's interesting that just yesterday, the media is reporting that, in fact, the economy was not impacted, as you had indicated in your opening remarks, by hundreds of millions of dollars. In fact, trade was up, industry, manufacturing was up 16% in cross-border traffic. And, you know, contrary to your assertion. Now, one of the things that that was intriguing to me is during the actual convoy protest here, you retweeted some information that was later shown to be completely false, completely inaccurate. So in your role as the Minister of Public Safety, how can Canadians now trust that the information you relied upon to invoke the Act in the first place was accurate and appropriately reliable?
Well, first, I want to draw a bright distinction between aggregate statistics and the real-life impacts and consequences which were caused by the illegal blockades which occurred in White Rock, BC, where I have visited, in Emerson, in Manitoba, where I have visited, here in Ottawa, and at the Ambassador Bridge in Windsor, where I visited. Speak to those Canadians, Mr. Motz. Speak to the small business owners who could not open because of the illegal and violent conduct which was being undertaken and engaged in by those who were doing it with the specific purpose of disrupting trade and travel. That was unlawful, and that was one of the reasons why we invoked the Act.
My question was very clear, very clear. The information you relied on, how Canadians trust you when you were tweeting out misinformation that's shown to be false, when you were tweeting this out, and yet you want Canadians to be able to trust you to say the information that I relied upon to inform Cabinet, to inform my own decision on whether or not we should invoke the Act in the first place. How can Canadians trust that now that all of a sudden, take my word for it, it's reliable, it's accurate? Without seeing it, we can't, you know, I certainly don't trust that it's accurate until I see it. And that Canadians are saying the same thing. Show us.
Well, I'm not sure there's a question there, except to say that I have faith in Canadians' sensibility.
I'll ask you a question. In my 35 years of law enforcement experience, I have a built-in BS detector, a built-in lie detector, if you will, and it's dinging big time. And the only way that it can be satisfied is you're undertaking to say, I will present to this committee every unredacted document that you should have access to make the decisions that we made to have a look at as a committee and and be transparent to Canadians.
Sorry, Mr. Motz, time is over.
Monsieur Fortin, just a point d'ordre. That kind of rhetoric is not really parliamentary and not really useful. We can certainly agree to disagree without being disagreeable, and talking about things like a BS detector is probably not very parliamentary. So I just ask us to all exercise a bit of discretion.
Merci, Monsieur Virani, pour le commentaire.
Thank you, Mr. Virani, for your comments. Mr. Motz, for your comments. Minister, I think we will try, and I think everyone's desire is to remain respectful in the context of our debates. Of course, these are debates, and we will try to remain respectful throughout. Thank you, Mr. Motz, for your comments. I realize I did not have any way to indicate that the time was up, so this is my new sign. This means 1 minute left. Is that the yellow or the red one? Well, it's the 1 minute one. Let's say yellow. And on the other side here, we'll have 30 seconds when you have 30 seconds left. That's as good as it gets for me today. Thank you. Ms. Bindawi, you have 5 minutes.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chair. Thank you to the Minister for being here with us here before the committee.
I do find it curious that the Conservatives on this committee are downplaying the economic and reputational impact of the closure, the blockade of international borders with our largest trading partner, the United States. Minister, I'll turn to you for a number of questions. There are a number of things I'd like to get on the record, so to the extent that you could provide succinct responses. At the time of the invocation of the Emergencies Act by the federal government at 4:30 p.m. Eastern on February 14th, is it not true that the blockade of our international border in Coutts, Alberta was ongoing and indeed would only be reopened on February 15th?
Thank you, Ms. Bendayan, and yes, to the best of my recollection, that is correct, although I would just emphasize to you and to the other members of the committee that while at the time of the invocation of the Emergencies Act, we were making some progress with regards to restoring public order, that we could not take it as an assurance or a guaranteed outcome. As I've said in the past, progress was not necessarily linear. And the advice that we were getting was that that law enforcement needed the Emergencies Act to be sure that they could resolve, for example, ambiguities around those who were provided that power to them.
Thank you. And is the response similar with respect to the blockade at our international border at Emerson, Manitoba, which was also still ongoing at the time of the invocation of the Emergencies Act? In fact, that border would only reopen on February 16.
Also correct, and as I said earlier in a question from Mr. Motz, I had the chance to visit Emerson and to speak directly with frontline CBSA officers and law enforcement who were there at the time. And I know, again, that, as you pointed out in your prefacing remarks, that some on this committee, even in our chamber, in the House of Commons, may have a different perspective on how to characterize this public order emergency. I would encourage them and anyone who doubts to speak with those who are engaged as part of the law enforcement response, the Canadians who had to shut their businesses, whose lives were upended. And there is a difference between having an opinion and a perspective and what is fact. And what is factually true is that at the time of the invocation, there were still ports of entry that were being illegally blockaded, and that had a huge and devastating impact, not only to our economy, but to our national security and safety.
In fact, there was another international border that was still being blocked illegally, and that was in Surrey, British Columbia at the time of the invocation of the Emergencies Act, and that border would only reopen several days later. That is your understanding as well, I believe.
Also true, and just to add a little bit more detail, I also had the chance to go to the Pac Highway port of entry, where once again I had the chance to speak with officers who were serving during the illegal blockades. They were there the day that blockaders took an armored vehicle and rammed it into a barrier for the purposes of disrupting public safety and further interrupting safe travel and trade. So once again, you can have whatever perspectives you want on debates and policy by this government, but there is no disputing those facts.
And similarly, we do know that there was a blockade, an illegal blockade of our Ambassador Bridge at Windsor, Ontario, a border crossing, as you know, through which $400 million of goods travels daily. And that border had only been reopened less than 24 hours prior to the invocation of the Emergencies Act. And in fact, there remained possibility of further blockades at the Ambassador Bridge. And I'd like to take you to, I guess, your ongoing concerns. I think that is a good segue to your concerns as Minister of Public Safety. Were you concerned at the time of the invocation of the Emergencies Act about our territorial sovereignty and about the security of our international borders, not only for reasons of trade and commerce, which are extremely important, but also for reasons of the passage of essential goods and services to Canadians?
Bendayan, but time is over. I don't know if the minister wants to answer. Yes. Pouvez répondre en peut-être
30 seconds, sir? Thank you for the additional time.
Answer is yes. We were concerned at the time. My concerns are ongoing, but we invoked the Act because it was the advice of nonpartisan professional law enforcement that existing authorities were ineffective at the time to restore public safety at all of the ports of entry that you mentioned, Ms. Ben-Dayan, and that was why we took the careful step, the thoughtful step of invoking the Act, and it worked.
Merci, Monsieur le Ministre.
Thank you, Minister. It will actually be my turn to ask questions, but I'm a bit uncomfortable asking questions while I chair the meeting, so I would ask Mr. Green to chair during these 5 minutes of questioning, and then I will come back to take the chair at that point.
Non, moi, en tant que président, j'ai...
As a chair,
5 minutes, the floor is yours.
Est-ce que je peux avoir le cadran, s'il vous plaît?
thank you, Minister, for being here. You've said, I think twice or 3 times since the beginning of the meeting, you've said that you received a notice that, independent advice that the Emergencies Act was required. Were these written notes, or was this written advice? There were a number of exchanges during the blockade. Sorry, I'm saying before you invoked the Emergency Measures Act, you said you received some advice. Was this written advice? Mr. Fortin, I'm actually providing an answer. There, of course, was a lot of communication between the government and the police forces. There are written communications. So, was there...
Oui. Est-ce que vous avez reçu des...
Did you receive written advice? Yes or no? In the context of your question, perhaps there is information that is covered by privilege. Sorry, I have 3.5 minutes left, Minister. I'm wondering if you had any written advice sent to you before you declared the emergency. I had already answered. There are written communications. There's an exchange of information. Yes. Thank you, Minister. The declaration indicates that there's an emergency throughout all of Canada, but as you know, along with the declaration, there is a summary of the consultations undertaken with the premiers of the various provinces and territories. You know that before you can declare a state of emergency, the government must, according to the Act, consult with the premiers. And this is a summary that's along with the declaration. I see that the Premier of Quebec was opposed to the application of this Act and that, in fact, it could be divisive. I see the Premier of Alberta was opposed to it being invoked. Also, the Premier of Saskatchewan was not in favor of it, that the Premier of Manitoba was not yet convinced it was a good idea, that the Premiers of New Brunswick, Nova Scotia, and PEI said it wasn't necessary. And we also see that the 3 territories, so the premiers from the 3 territories, provided feedback without issuing any public comment. So, all told, 7 provinces and 3 territories did not seem to fear a situation, an emergency in their areas. So, really, you have Ontario, BC, and Newfoundland left. Minister, my question is this. How can you claim that there is an emergency situation throughout all of Canada, whereas when you actually issued the emergency order, 7 out of 10 premiers are saying, listen, everything's fine over here, there's nothing wrong. Some are even saying, don't do this, this will be divisive. How can you claim that in this context there is a global emergency throughout Canada? Answer, Mr. Fortin, that's a good question. There is a principle calling for consultations that is part of the process before the Emergency Measures Act was invoked. We upheld that principle. We had conversations, a number of conversations with our provincial and territorial counterparts. This was an ongoing process, in fact, before the emergency measures were invoked and also during the implementation of the Act, enforcement of it. So we had acted in good faith and had been in communications with the provinces and territories in consultations. At the time, there was an emergency situation underway, and we had created the situations in order to restore public safety. Thank you for the yellow card. I have 10 seconds left, Minister. Once again, these are not my comments here. I'm reading the comments of the government here stating that everything is fine in 7 out of 10 provinces. I'm somewhat surprised. Thank you. My time is up.
Happy to give you back the seat.
Merci, Mr. Green.
Thank you, Mr. Green. Mr. Green, you have the floor. 5 minutes.
Honourable Minister, would you agree that in invoking this declaration, every single word within the declaration would have a specific meaning?
Yes.
And that in this case, in a very legal, probably the most extreme legal piece of legislation we have, every word matters?
Yes, I do.
So the proclamation declaring a public order emergency made on February 14th specified that the public order emergency constituted of 1, the continuing blockades by both persons or motor vehicles that is occurring at various locations throughout Canada, and, with emphasis, I will add, that the continuing threats to oppose measures to remove the blockade, including by force, which blockades are being carried out in conjunction with activities that were directed towards or in support of the threat or the use of serious violence against persons or properties, including critical infrastructure, for the purpose of achieving a political or ideological objective within Canada. Through you, Mr. Chair, to the Honourable Minister, I want to reference Section 83.1 of the Criminal Code, which defines terrorism as an act committed in whole or in part for a political, religious, ideological purpose, objective, or cause. Given that criminal definition, would you agree, given the language that you used in the proclamation, that this was considered a terrorist threat?
I would agree that that section is imported into the test for the invocation of the Act, as you have referenced, and you're right. We were very attentive to the precise language and legal test that was required to invoke the Act. One of the reasons why I said in my introductory remarks, Mr. Green, that the so-called Freedom Convoy began the way that it did was to be sure that all members and all Canadians are aware of part of what incited the assembly and the amassing of large numbers of people in the thousands at official ports of entry, in our communities, in our neighborhoods, and here even at the seat of the federal government.
Thank you. And through you, Mr. Chair, you also, I heard reference to a violent overthrow, and the Honourable Minister used the term ideologically extreme goals, and yet in the declaration itself, it seems to be an overemphasis of the blockades and the impacts on the economic good. And I think we can all agree around the table that we have a responsibility for Canadians to know the seriousness of this threat, one in which the Commissioner Thomas Carrick of the OPP in testimony before the Public Safety Committee talked about on January 13th, the OPP intelligence reporting sought that this was a high risk of critical events. And in fact, I'll reference number 5 of the proclamation, which talked about the potential for the increase in the level of unrest and violence that would further threaten the safety and security of Canadians. Understanding those 2 points, Mr. Chair, and through you to the Honourable Minister, noting that threats to security for the purpose of the public emergency order are defined as meanings assigned to Section 2 of the Canadian Security Intelligence Service Act, I would like to know what considerations were you briefed on, given the threat of national security provided both by the OPP and, as I'm to understand, ITAC in the weeks leading up to the procession and the eventual occupation of Ottawa.
Well, of course, I want to be respectful to the sensitivity of intelligence reports that were given to the government. And I do know, Mr. Green, that there is, I believe, a motion before this committee to determine the level of access to that information. And I, encourage you to undertake those deliberations independently.
If I could, thank you. I want to be specific here. What is the factual basis for the objective elements that were considered when you were looking to perhaps rescue charter breaches under Section 1? You talked about facts over opinion, and I'd like to know the factual basis for which those elements, the 6 points for temporary measures, were dealt with.
I want to be sure I understand your question. I'll try to answer it, and if I'm off track, then you'll let me know. But one of the features of the Emergencies Act, unlike its predecessor, the War Measures Act, was that it ensured that any measures that
Mr. Chair, thank you. This is not the direction that I wanted to go in. What I'm looking for, sir, is that there were 6 elements, 6 types of temporary measures, and I would be assured that the government would have gone through a charter breach analysis, would it have not?
We wanted to be sure.
So would you be willing to share with this committee the factual basis for which you have objectively and factually, not through opinion? Yes or no, would he be willing to share the factual basis for the charter breach analysis?
I would assure you and all colleagues, we want to be transparent, but what I was getting to was that the measures that we included in the Emergencies Act were compliant with the Charter, and that is a requirement of the Emergencies Act.
Merci, Monsieur le Ministre.
Thank you, Minister.
La parole va être maintenant.
Now on to Senator Boniface. You have 5 minutes.
Much, and through the chair, thank you, Minister, for being here. I'd like to zero in somewhat in following up on the chair's question around the jurisdictional issues in policing, and we're a convoluted country when it comes to policing, as we saw. We have the Ottawa Police. I'm going to focus on Ottawa in this question, and the RCMP obviously serving some aspects here on Parliament Hill in different capacities. And since jurisdiction for policing falls under the province of Ontario, which I'm quite familiar, the province has a role to play in the process. So in this situation, where both the city and Ontario, both the city and Ontario declared emergencies and indicated, I assume, that therefore came to the federal level asking for assistance. Did you go behind the declaration of emergency at the city and provincial level to see whether or not they had exhausted their own authorities?
Well, I want to come to that, but before I do, I really want to acknowledge the premise of your question is, I hope, going to be studied very carefully by this committee, namely how different branches of law enforcement are able to cooperate and how different jurisdictions are triggered and implicated, including here in the capital. And, having spent some time now here along with all of you in the city, I am aware now, as you all are, very painfully so, that Wellington Street is under the jurisdiction of the Ottawa Police Service, and that did, if I'm to be very candid, I think present some challenges for all law enforcement in the response in the early, certainly in the early days and into the period after that of the illegal blockade. So I do hope, and I embrace this committee's work on how we're able to navigate that jurisdictional terrain, particularly here in the parliamentary precinct. As we took our decision and what we could do to respond, we were following the advice of various levels of law enforcement, including the RCMP and the commissioners on the line. But we wanted to be sure at bottom that we were giving law enforcement all of the tools and the resources that they needed to respond. And it was only after that period of time when existing authorities, and there are existing authorities on the books, and we're all very aware of that, were ineffective at restoring public safety. And that is perhaps another area that, we encourage this committee to study very carefully, and we embrace this as a healthy exercise.
I guess, so I appreciate with Wellington, my question I'm trying to get to is how the layers of an emergency order at the city, then the province, which is very unusual for a province to declare the emergency, given they have a provincial police service and their capacity to be able to assist the city as policing falls, as you know, under the province, and then layering in the federal role. And so the question I was trying to get to is, did you take at face value that they had exhausted their resources and their capacity to be able to do something at the provincial level to bring in the federal assistance?
I would say that certainly we were aware of the fact that the province had invoked its own provincial equivalent emergencies legislation, and it occurred before we invoked the Federal Emergencies Act. So without question, that would have been something that would have been on the minds of those of us who had to take the decision. But I would circle back to what I think you began with, which is a very important question, and that is, you're right that in Ottawa, it is the Ottawa Police Service that has the local jurisdiction, including on Wellington Street, to ensure public safety. But how that intersects with the Ontario Provincial Police, when they have exhausted their local resources to respond, and then if the Ottawa Provincial Police are unable to restore public safety on their own, how other branches of law enforcement are implicated, including the RCMP, is a very, very important question.
Le temps est écoulé, Monsieur le Ministre.
Your time is up, Minister. Thank you, Madame Boniface. Who has the floor? Senator Carignan. Go ahead. Thank you, Mr. Chair. Look, I'm still trying to understand how you were able to invoke the Emergency Measures Act. I'm hearing you. I'm listening to you. You seem to be convinced. But I think there is something going on. Let me start by my first question. Do you know the Highway Traffic Act 130 Section 134.1 of the Highway Traffic Act in Ontario? Is there anyone in your office or among your advisors who might have said there is such a thing as the Section 134.1 of the Highway Traffic Act? Listen, I'm generally speaking aware of the fact that there are authorities that are on the books that exist for police forces that they can use to restore public safety. But at the same time, I want to assure you that at that point, that authority was not effective, was unable to restore public safety, and that is the reason why we took the decision to invoke the Emergency Measures Act. And the evidence and the situation on the street, on Wellington Street, at the borders, was evident. It's not simply the government's advice or opinion. Before you invoked it, I mean, that's not the first train blockade or highway blockade that's ever happened in Canada. Things were always managed through injunctions or the exercise of municipal police powers, provincial powers, federal powers. There was the Oka crisis, the army was brought in, and the blockade was removed. In what way was it necessary to invoke the Emergency Measures Act to tow vehicles on Wellington Street? I mean, I'm speechless. With all due respect, the emergency situation in the end of January and the month of February was unprecedented because all of the blockades occurred at the same time, and the level of disturbance was unprecedented. The level of the disturbance in the streets of Ottawa was unprecedented. There were people barbecuing in the middle of the street. Some people had a jacuzzi. Section 139 allows the police officers to tow a vehicle when it is impediment to traffic. There were so many police officers there. Not one of them wanted to order to tow this truck and to have the tow truck come in and then and do that, as was done once the Emergency Measures Act had been invoked. There's nothing that was done under that act that the police officers couldn't have done beforehand. You agree with me? Look, you're right to say that there is an act, but the act was not effective.
One of the challenges, un de les défis,
one of the issues was that the tow trucks were not available
to secure the tow trucks. There were threats. There were interruptions at the time, and that was one of the pieces of advice that we were getting at the time.
Minister, I found some for sale on Auto Hebdo. You could have bought some and towed them yourself without having to turn to the Emergency Measures Act. The Act gave the police officers the power to go into the vehicle, grab the keys, tow the truck, and leave with it. According to the Act, you didn't need this Emergency Measures Act. So if your province needs this, go to the tow trucks that the Army has, buy some tow trucks. Don't use the Emergency Measures Act to tow vehicles. It makes no sense. Senator, once again, police forces tried, but they were not successful. And that is the reason why we needed to make the decision to invoke the Emergency Measures Act. Your time is up, Minister. Thank you. Mr. Carignan.
Parole est au sénateur.
Now on to Senator Harder.
Merci, Mr. Fortin. Minister, welcome. I want to pursue a little bit the questioning of Senator Boniface. I'm a senator from Ottawa, as you might know. My question is, what took you so long? Why did it take 3 weeks of the disruption that Ottawa had visited on? I respect that you've got the others on the border, but I want to talk about Ottawa. Why did it take 3 weeks for you to act?
That is a totally fair question. And I assure you that as we embark in this review, we are thinking very much about the amount of time that it took to transition from the local police of jurisdiction to the provincial police who are there to backstop where local police don't have the resources that they need. But I also want to remind and underline that notwithstanding the absence of there being a law that explains exactly how we move from local, provincial to federal, that the RCMP were consistently offering whatever additional personnel, tools, and resources to support the local police of jurisdiction to try and deal with the blockades. And the other thing I would say, Senator, is that it is an important principle to recall that as a matter of day-to-day operation, you do not want elected officials stepping into the space of the police. It is well established that we write the laws as parliamentarians, and we expect that our police enforce those laws.
But the community also, though, expects the elected officials, municipal, provincial, and federal, to act with greater alacrity in the face of the situation that we had than waiting 3 weeks. In your testimony earlier, you said the advice we received was to invoke the emergencies measure. From who did you receive that advice? I don't need names, but I'd like, are you saying all levels of government? Are you saying only police, but also political jurisdictions that have a responsibility to advise? I'd like you to elaborate on that so that we can be assured, in Ottawa at least, that you weren't just waiting around for the opportunity.
No, I assure you, we were not. And there was a community of different partners within the public safety and national security apparatus, as well as the consultations that we were undertaking with different levels of government, including those who were directly impacted by the illegal blockades across the country. So there was a very robust discussion. And the other thing I would offer as context, and I realized certainly at the time, and I know for those who live in Ottawa, that particularly in Ottawa, how difficult it was, that because this was the first time that we were invoking the Emergencies Act, that we went to great pains to get it right. And in retrospect, I do think that the entire episode and the saga does expose a number of questions, which have been raised by colleagues at this table around interjurisdictional cooperation, how reinforcements are set. It is my hope that at the end of this process, you will be able, all of the members of this committee will be able to offer your best advice, your best recommendations, having regard to the challenges that we encountered.
I'd just like to ask one quick question. Can I infer from your response that all jurisdictions necessary, provincial, municipal, and federal, were coordinated in their advice to invoke the Act?
I would say that there was a very strong consensus that we needed to invoke, and I would again offer that the Canadian Association of the Chiefs of Police, the Ontario Association, the Canadian Association, law enforcement was very strong
What
in its.
caused the short of unanimity to make it consensus? Who wasn't?
Well, I don't want to speak for every last serving member of law enforcement, but there was a very strong consensus that we needed to invoke the Act.
Your time is up. Thank you, Minister. Thank you, Senator Harder. Now, Senator Kendall, you have the floor. 5 minutes.
Thank you, Chair, and thank you to the witness for being here. Chair, can I address this to Commissioner Lucky, or is she coming later on?
Oui, vous pouvez poser la question.
You may. She's here. She's online virtually.
Commissioner Lucky, thank you for being here. Can you tell us on what date the RCMP became a seated member of the management team dealing with the Ottawa lockdown?
Thank you for that question. Well, right from the beginning of the protests, we had a role to play. We were obviously, in the initial instances, we had our own mandate of protecting the parliamentarians and the Senate, and we had a national Capital Region Command Center that included Ottawa Police Service, OPP, and other police of jurisdiction. We also had a joint intelligence group where we worked together throughout the protest. And then when it came to enforcement actions just prior to that weekend of enforcement, we had created a planning cell, a joint planning cell with an integrated command center specifically for the enforcement. But we were helping them throughout with frontline policing duties as well as other
So from the very beginning,
resources.
From the very beginning, you were at the table?
Yes.
Okay. The second one is, can you advise us what actions the RCMP took in relation to security on the Hill as the agency responsible for the management of PPS?
Well, first and foremost, there was we ensured that the Parliament Hill did not have access to any type of vehicles and protesters. For the parliamentarians themselves, we provided a service because when things started to get tense, we had determined that the threat was higher for parliamentarians walking to and from Parliament. So we provided a staging area that allowed for parliamentarians to meet if they so wished, to get driven into Parliament. We also provided additional security for the Senate. The last thing we did was in regards to when we were getting into more kinetic enforcement actions, we actually closed the Parliament for one day to ensure that there was no people coming back and forth. And we were also part of like I said earlier, the National Capital Region Command Center and providing assistance with various resources.
Thank you, Chair. Thank you.
C'est fini.
Done? Okay. Now on to Mr. Brock. You have 4 minutes.
Thank you, Mr. Chair. Thank you, Minister, for your attendance today. I would like to start off by questioning Ms. Lucky, Commissioner of the RCMP. Ms. Lucky, do you acknowledge and agree that the RCMP is independent of the federal government and is free to investigate without influence?
Yes.
Has the RCMP ever been influenced and or deterred by the federal government to investigate a criminal matter?
Not to my knowledge.
Is the RCMP free from any influence or direction by the federal government to lay a criminal charge?
Absolutely.
If the subject matter of an investigation is the Prime Minister himself, are you concerned about any government interference or reprisal?
No.
Can I ask on a point of order, Mr. Fortin, what is the relevance of this line of questioning? I think you're exercising a large degree of latitude, and I've yet to see any relevance whatsoever to...
I think it's difficult to determine the relevance at this point. We can let him go on, and if we realize it's not relevant, I agree with you, but for the time being, we have to give him some latitude.
The measures that were undertaken pursuant to the scope motion that Mr. Brock himself voted for, and that's with respect to the enforcement measures taken under the Emergencies Act.
Monsieur Brock.
I suggest we listen to Mr. Brock, hear his line of questioning. I'm not sure, but I would imagine that there is a link there.
Ms. Lucky, are you aware that today in the House, during question period, the Prime Minister admitted that he did not give himself permission to accept a free vacation from a federal lobbyist?
Completely irrelevant.
Mr. Brock? I'm going to have to agree with Mr. Villani, Mr. Brock. Unless you have an explanation to provide, I don't think this is relevant to our current study on the declaration of the state of emergency.
And to my colleague from the Liberal government that raised the point of order, I respectfully disagree. The Prime Minister is head of government. The Prime Minister was the lead voice in the invocation of the Emergencies Act. He is now under a cloud of suspicion with respect to the offense of fraud. Fraud is offense of dishonesty. Dishonesty involves the matter of integrity and character. And Canadians
I think
have
Mr.
a right.
Brock has made his point, and you've made a ruling.
I have the floor right now, and I'd like to continue my response.
Mr. Fortin, you've made a ruling. If we need to vote to endorse that ruling, I'm happy to call a vote.
Je veux juste qu'on laisse Monsieur Brock expliquer.
I would just like us to give Mr. Brock an opportunity to explain things. His comments I've said are not relevant. He's trying to make an argument to try to convince us. I'm listening, but he hasn't yet caused me to change my mind. I'm going to let him have this opportunity to continue to explain things. Are you done, Mr. Brock?
I had one final point.
Okay.
On the issue of integrity and character and honesty, Canadians have a right to know whether or not our head of government has been compromised because of his involvement in this particular matter, and hence There has been an erosion of trust in the federal government.
Je m'excuse, Monsieur Brock, mais
I'm sorry, Mr. Brock, but thank you, Mr. Brock. I'm maintaining my decision in that this line of questioning is not relevant to our debate. You still have 2.5 minutes left. I'll give you an opportunity to continue.
Oui.
Mr. Chair, I believe his time is up. I suspended the time during the time of the argument or the debate on Mr. Virani's objection. There were 2 minutes and 42 seconds. So I'm going to give Mr. Brock an opportunity to continue his comments, so long as he remains relevant. So no accusations about the Prime Minister that might be relevant in the House, but not here. Thank you, Mr. Brock.
Now on to you, Minister. And I'm not going to accuse you of anything. Minister, with the time I have available, I'll try to get a couple of questions in. You'd agree with me that the government was not caught by surprise by the arrival of, your words, the so-called Freedom Convoy, that it in fact had been heavily publicized in social media, that the organizers of the convoy took appropriate steps to liaise with the Ottawa Police Service, with the Parliamentary Precinct Service, with the Mayor and City Council to announce their arrival. They were given permission to park on Wellington and adjacent streets. So you'd agree with me that it started as a peaceful protest, a protest that is so vigorously protected by our charter. Section 2, the freedom of assembly. Our democracy gives Canadians the right to voice their opinion with respect to any government policy. And what started off as a peaceful protest, in the words of the government, became an illegal protest. So the focus of my question is this: at what point in time, when and what were the circumstances that caused the federal government to determine that what existed outside of West Block constituted an illegal protest?
Well, I would disagree with you, Mr. Brock, on a number of the premises underlying your question. First, from the outset, as I stated in my introductory remarks, the frame of the leadership of this so-called Freedom Convoy called for the overthrow of the government. They called for the Governor General to remove unilaterally the Prime Minister from office if...
Well, let me stop you right there.
So I just want to underline I disagree.
That's fair.
Yeah.
Let me stop you right there, because that was a second line of question. We all know that there is a legal threshold before the invocation of the act was warranted. You and several other senior ministers, as well as the Prime Minister, deemed this to be a threat to public safety. And quite often you would refer in the House to the Memorandum of Understanding or the Manifesto. You'd agree with me, sir, that there was no language in the manifesto.
Time is up, Mr. Brock. Sorry, your time is up.
La parole est à
Now, on to Mr. Nakvi. 4 minutes.
Thank you very much, Chair. Minister, thank you for having me. Let me just ask you a couple of questions just to get some foundational things out of the way. As a Minister of Public Safety, do you have the authority to give police instructions on operational matters?
As a matter of general principle, no, we do not.
And do you have authority to instruct police on use of force matters?
No, we do not.
Are you aware of that authority being extended to any elected representatives at any order of government in Canada?
No.
Thank you. I want to speak about what was happening in Ottawa. And I am from Ottawa, so it's close to my heart. You recall that a big part of downtown Ottawa was completely shut down, with hundreds of big rigs and trucks and vans and cars blockading all street?
Of course I do. I am a resident of Ottawa from Sunday night to Friday evening, all sitting weeks.
And that lasted for about 24 days?
Yes.
You also recall that there was noise honking at all hours until a private citizen sought an injunction and stopped it temporarily?
Yes, and that was the tip of the iceberg, but yes.
Do you also recall reports of fireworks being held on downtown streets where people live in the middle of the night?
Yes, and worse.
And you recall general atmosphere of partying mixed with use of alcohol and harassment and intimidation towards the residents of downtown Ottawa?
Mr. Nakvi, I think we were all, those of us who were here, generally aware of the boisterous atmosphere, but it was far worse and criminal. And that's one of the reasons why hundreds of charges were laid. Again, decisions taken independently by police.
And Minister, did you get the sense at that time when you were getting all the briefings and you were engaged in conversations and being here yourself, that there was a sense of breakdown in public trust as to how this occupation will come to an end in case of Ottawa?
I would think, Mr. Nakvi, that during the time that I was aware that there was a high degree of anxiety, concern, frustration, and anger, which was regrettably justified in the circumstances, when residents can't get to work, when they can't take their children to school, when seniors can't get around because public transportation can't get to them, when people who live in apartment buildings find that their front doors are locked and that fires are set in the hallways and corridors.
Point of order, Speaker.
It is
Un instant, Monsieur le Ministre. Oui, Monsieur Mott.
That statement right there has been proven false by the Ottawa Police Service, and there is no connection to the protesters whatsoever. And for this minister to suggest that is absolutely unacceptable at this committee.
Mais je pense que le témoin peut répondre.
I think the witness can answer the question. It can be frustrating if the answer is not relevant, Mr. Motz, but I don't think it's illegal for the witness to. Really, the questions have to be relevant, so I'll allow the minister to continue. You have 50 seconds left. Thank you.
Yes, Mr. Nakvi, there was definitely a lot of anger and frustration.
So that was the foundation, that was the basis upon which you had to make certain decisions as to how to bring an end to this illegal occupation. And were you getting advice as to what tools police may need to finally bring an end to that 24-day occupation?
Yes, of course.
And that led into the circumstances of various measures that you outlined in that Emergency Act order?
Well, as I've said on a number of occasions, one of the principal reason why we invoked was that the existing authorities that were on the books, and we've heard references to different statutes, the Highway Traffic Act, the Criminal Code, all have provisions, but for a variety of reasons, mostly dealing with the unprecedented and sustained nature of the illegal occupation in Ottawa.
Your time is up.
Invoke.
Merci, Monsieur le Ministre.
Thank you, Minister. Thank you, Mr. Nakvi. Now, for the member for the Bloc Québécois, which is me, I would invite my colleague to chair the meeting. Minister.
Just a reminder on the minute. How long is the duration of this?
3 minutes.
3 minutes.
3 minutes. Monsieur le greffier.
The clerk will.
First for 3 minutes.
Yeah, merci.
Thank you, Minister. I'm listening to you testify, and I have to admit I'm not reassured if I understand you cannot provide instructions to any police officer nor any authority to prevent that events of this nature take place. You're saying you are aware and have been since the very beginning. You live in Ottawa, you heard honking, you were a witness of the blockades in the streets, you're the Minister of Public Safety, and you are telling us that there was nothing you could do and you had no authority to do anything. And clearly police officers, for a reason that I'm unaware of and cannot quite understand, I hope will understand by the end of our work, but the police officers did not find it advisable to act either. If I understand your testimony, anyone could come back and really park anywhere in Ottawa and then add a few trucks along the way, set up a jacuzzi and some barbecues, and we'll be here with our sitting on our hands and waiting a few weeks to finally say, okay, we can invoke the Emergency Measures Act. Is that really what you're saying, Minister?
No, pas du tout.
No, not at all. From the beginning of the blockades, the government took concrete action. For instance, we added resources in the field with the cooperation of the RCMP. We were in close contact with the City of Ottawa, but throughout Canada, at the borders, at these communities in Windsor, we added resources, we added personnel. There were 3 facilities there for the RCMP to support the police that had jurisdiction in the region. This was before the Emergency Measures Act. I'm talking about what happened in the City of Ottawa. You witnessed this from what you're saying. The blockade was so serious that you ended up invoking the Emergency Measures Act, which to my mind was not necessary. That's my view, of course. I guess we'll see. But at this point, it seems to me you're confirming that there was nothing else you could do. What Senator Carignan was saying, the Highway Traffic Act in Ontario would have allowed you to clear the road. It seems clear to everyone. I mean, everyone I speak to says, well, look, it's normal for police officers to... But listen, nobody seems to understand that a situation like this could have lasted so long as to lead us to this point. It seems to be quite lax. It's unacceptable, almost irresponsible, Minister, with all due respect. Please explain this.
Briefly, please, Mr. Minister.
Tout d'abord,
first off, despite the existence of provincial authorities, the province of Ontario invoked its Emergency Measures Act. In its view, so that the province made that decision. That was before this act was invoked at the federal level. And what I was saying was that we took many steps to help police forces in Ottawa before invoking the Emergency Measures Act.
Alors, je reprends.
Okay, I would feel like going on longer, but...
To finish the
Monsieur Green, la parole est à vous.
Mr. Green, you have 3 minutes.
And we're going to go back to some of the definitions. You'll note that in the definition of the national emergency under A and B, there's an "and" clause that says cannot be effectively dealt with under any other law of Canada. We've heard today that expert advisors advised the government that they did not have sufficient authorities, and yet there's been pretty wide reporting on perhaps there being insufficient will on behalf of our public safety police. And so I note this, that in the reasons for the public order emergency, the convoy supporters formerly employed in law enforcement and the military have appeared alongside organizers and may be providing them with logistical and security advice, which pose operational challenges. This is noted. I ask that because in Section 5, where it talks about the potential for an increased level of unrest and violence, it is noted that there are individuals who support ideologically motivated violent extremism. This is a very serious issue for me in this particular case. So my question through you to the Honourable Minister is, noting that there are members of ideologically motivated violent extremists and the convoy supporters had formerly employed law enforcement and military people within the organizational capacity of the occupation, would the minister agree that there could be and evidence of ideologically motivated elements within our law enforcement and the military?
Well, I would begin by pointing out that first, with regards to the threat, as I mentioned during my introduction, there was a rhetoric that was ideologically motivated, and that led to...
Mr. Chair, with specificity through you, respectfully, to the minister, we have people who are coming from, you know, the Prime Minister's security detail, Joint Task Force 2 members, None of this, by the way, captured within the declaration. So I'm going to put the question, my final question through you, Mr. Chair, to Director Vino from CSIS. Did CSIS at any time provide the government with information that would have met the threshold outlined in Section 2 of the CSIS Act?
Merci, Monsieur le Président. Thank you, Mr. Green, for your question. I would say that that as part of the Emergencies Act refers to the CSIS definition of violence, of terrorism. But the information from CSIS is but one of the elements that the Governing Council would consider to make its assessment. CSIS has been involved throughout the demonstrations and the protest to carry out our mandate, and we have been providing advice to the government.
Chair, yes or no? Did CSIS provide
Your time is up.
to the ministry that met the threshold of Section 2 under the CSIS Act? Yes or no?
Yes or no, monsieur?
Oui or non, en français, please.
I cannot respond by yes or no, Mr. Green. Just have to
merci.
say that we have provided.
Thank you. Your time is up. I'm sorry. I feel quite impolite by interrupting you this way, but those are the rules. 3 minutes, Senator Carignan. Thank you. Minister, I'll be asking you a question that's already been asked. On February 25th, 2022, at the House of Commons Committee, Member of Parliament McGregor asked you a question. I'm going to ask you the very same question that you didn't answer. It's a yes or no answer. Minister, before February 14th, did the Prime Minister or yourself receive any request from the Conservative government in Ontario or Premier Doug Ford asking to invoke the Emergency Measures Act? Period. That's the end of the quote.
Elle se répond par oui et par non.
Really, it's a yes or no answer.
Monsieur le Sénateur,
Senator, I engaged with the Premier of Ontario to discuss the situation here in Ottawa and throughout Ontario. I'm not the only member of government who was in contact with the Premier of Ontario. In fact, I'd engaged with my counterpart, Minister Jones, Secretary of Public Safety for Ontario. So there were very informative conversations that took place. You're not answering my question. Did they ask you? Can you tell us? Did someone say we can't deal with this, we don't have the means, we don't have the power to address the situation? Minister, save us, pass the Emergency Measures Act. Was that asked of you? Yes or no?
Monsieur le
Senator, I want to reassure you that there is a lot of cooperation between the province of Ontario. The answer is no. And the federal government to ensure that we can restore public safety in our communities. So what I gather from this is your answer is no. We had close cooperation with the province of Ontario before and after the Emergency Measures Act was invoked. I don't know if we can get tears from a stone. I don't think we'll get there.
C'est tout, monsieur.
That's it, Mr. Carignan? Yes? All right. Senator Boniface, you have 3 minutes.
Thank you very much. I'm going to come back to the jurisdictional issues because I want to have it very clear in my mind. From two fronts. One from the blockades here in Ottawa, from the time it went from a legal occupation to an illegal one, or from a blockade or a protest to an occupation, illegal sense. And then secondly, and perhaps the Commissioner or someone else may be able to give more details, secondly on the question of the role of the province. I appreciate the collaboration that you refer to, although I remember reading, and this may have been reported inaccurately, that the Minister for Public Safety in Ontario wasn't present at some of the meetings that took place when these discussions were taking place. I assume from that meant there was nobody from the province showing up for those. And so I'd just like to confirm that was an accurate reporting, number one. And then the number 2 point really is, as you move from at least from an observation perspective of a protest to an illegal occupation, when that threshold moves, how did that change in terms of resources required or asked for at the city and provincial level?
Thank you for the question, Senator. In the first instance, I want to assure you and all members that there was good communication with the province of Ontario, including my counterpart, Minister Jones, during the blockades. We wanted to make sure that we were staying in contact so that, frankly, we could support our respective efforts to provide law enforcement with whatever additional tools that they needed on the ground, and specifically the Ottawa Police Service, who, as you heard throughout and earlier in my testimony, were overwhelmed at times, and significantly so as a result of the large number of individuals who were participating in the occupation in Ottawa. And so there was good collaboration there. And I would say, in terms of the second part of your question around the sort of pivotal moments, we were listening very carefully and watching very closely how public safety was deteriorating and eroding as a result of the surge in individuals who came to Parliament Hill, and it became very clear that they were not going to leave, and they began to put up fixtures. They began to become firmly entrenched, not only on Wellington Street.
Le temps est écoulé, madame.
Time is up, Senator.
Certainly, those were the factors we were looking at.
Okay. Je vous remercie, Monsieur le Ministre.
Thank you, Minister. Senator, your time is up. I apologize. We have about 10, 12 minutes left. I would recommend we go back to the first round, except 1 minute per party, so that we can make best use of our time. Is that all right with everyone?
Oui. Alors, je donne donc la parole au premier intervenant.
Conservative member, Mr. Motz, 1 minute.
Thank you very much. Minister, the Emergencies Act, the Prime Minister said that it was geographically targeted, and yet the wording in there is for all of Canada. You know, it's throughout Canada, I think, is the wording that's actually in the regulation. And you know, I think everybody would agree that that's how it was applied. It was throughout Canada, is the Emergencies Act. And so it makes me wonder, in that circumstance, the public order was made on February 14th, and you know, so the declaration was made, and then on February 16th, we had the Coastal GasLink. We had the Coastal GasLink violent attack that an order paper question that came through yesterday indicated that actual incident met the threshold as defined in the emergency measures regulations. So I'm curious to know why the government did not respond to that violent attack using the Emergencies Measures Act as opposed to the
Votre temps est écoulé, M. Motz, désolé, mais c'est vite passé 1 minute.
Sorry, Mr. Motz.
OK, ben, je vous remercie, Monsieur le Ministre. Mais...
Thank you, Minister. Mr. Virani, you have a minute.
Just yes or no, please. It's true that the Alberta government put in a written request for assistance at Coots, is it not?
Yes, they did.
Okay, and it's also true that there were tow truck companies in Ottawa that were threatened with death if they assisted in removing some of the convoy truckers. Is that correct?
We were advised of that.
And the Ontario Emergency Declaration did not address towing or the commandeering of essential services. Is that correct?
It remained a challenge prior to the invocation of the Federal Emergencies Act.
And the Ontario Emergency Act, when it talked about removing the vehicle licenses for vehicles, obviously only applied to Ontario-plated vehicles and not to Alberta-plated vehicles, for example. That's correct?
That was another issue that came up.
Okay, and Doug Ford, specifically when consulted on the invocation of the Act, said, I support it. That's what's tabled in the House of Commons. That's correct?
He did.
Okay, and further to Ms. Bendine's questions, on February 16th, there was actually a further attempt to erect an illegal blockade in Windsor, and the tools under the Emergency Act assisted in ensuring that that blockade was not resurrected at that time.
Votre temps est écoulé, Monsieur
Your time's up, Mr. Vriani. Yes or no, Mr. Mincher?
Would just add to that, that the mayor of Windsor was also threatened during that period.
Thank you, Minister. Sorry. It's my turn. Minister, or Mr. Green. This is a funny process, but Minister. So I'm asking questions at this point. Minister, you said you received a written advice before invoking the Emergency Measures Act. Can you produce that for us? I would imagine that's not difficult for you to do, yes or no?
Monsieur le Président.
Mr. Chair, I know. Let's say between now and next Tuesday, 5 days. I know there's a motion on the table. No, put aside that motion. I have 30 seconds. Can you give me a copy of that particular advice you would have received in writing before you issued the emergency order? Mr. Chair, if you write to us, we will respond to the request. Minister, what takes precedence? These written notices that we don't know about or from whom they are, or the act that states that you must consult the premiers of the provinces? What takes precedence in you making these decisions?
Lequel des deux?
Which of the two?
Temps est écoulé.
And now my time is up. Can you answer?
Prochaine fois.
Next time.
Je soupçonnais. Merci, monsieur.
I expected that. Thank you.
Sénateur.
Senator Boniface. Rather, Mr. Green, 1 minute.
Thank you. This question is for Commissioner Lucky. On February 15, 2022, a video surfaced of the RCMP shortly after they found a weapons cache and were clearing out the Coutts blockade. The RCMP were shaking hands and giving hugs to convoy members, which is in stark contrast to how the RCMP treat Indigenous people protesting in relatively remote areas, such as the Wet'suwet'en, where firearms are not found present. What do you say to Canadians who have called out this clear double standard? And also, may you please respond to the observations of the RCMP being sympathetic to the convoy, which may have affected how they chose to discriminately enforce the law?
Thank you for that question. This convoy was particularly different in the sense that there was many people in and around the area, and not all people were involved with the convoy. There were citizens from the city of Ottawa who were not participating.
Specific to Coutts, Commissioner Lucky, there was weapons found at Coutts. In the same location, your RCMP officers were seen giving handshakes and hugs in a scene that had just recently found weapons. So would you care to comment on that?
Your time is up.
À moins que vous puissiez répondre.
Unless you can answer with a yes or no answer, Ms. Lucky.
OK, alors je vais
I don't know what I'm saying yes or no to.
OK. Alors je vais donner la parole.
All right. I apologize. Madame Boniface, 1 minute.
Yes, thank you very much. And through you, Mr. Chair, perhaps I could address my question to Mr. Vigneault. I can't see whether he's still on the screen or not. Perhaps, Mr. Vigneault, you can advise, were you surprised by the information you received with respect to the convoy and some of the issues that you saw as national security threats?
Thank you for your question, Senator. We are, as an intelligence organization, we are constantly looking at the movement of ideologically motivated violent extremists. So we have a fairly good understanding of the dynamics at play. So I would not necessarily say that we're surprised. We also saw in the past a number of these elements who are trying to use protest and demonstration to infiltrate and take advantage to engage in activity that can meet the threshold of CSIS to be a threat of terrorism. So from that point of view, I would say that we are constantly on the lookout for these issues. And that's what we're assessing, and based on our information and advice, providing assessment to the Government of Canada.
Merci.
Thank you. The time is up. Thank you, Madam Senator. Senator Carignan, 1 minute. Thank you, Minister. What are the orders of government or the provincial governments that asked you prior to February 14th to... Who actually told you we don't have the power to address this situation, we don't have the tools to address it? Which provinces told you that before February 14th?
Avant l'invocation.
Before invoking the Emergency Measures Act, We had engaged with the provinces and territories to understand their needs. As I've already said, there was a request from the Premier of Alberta for additional resources. This engagement process was an exercise that was ongoing. Perhaps I didn't ask my question clearly enough. What were the provinces that specifically asked you to invoke this? Answer, we engaged with a number of provinces during the blockades. Your time is up, says the chair. Thank you, Minister. Thank you, Mr. Carignan. Senator Harder, 1 minute.
I'm going to follow up to Senator Boniface's question to David Vino. Can you describe to us how the resources being allocated to ideologically motivated violent extremism have increased in the last, let's say, 2 or 3 years? And do you forecast an increase in the resources dedicated to this movement?
Thank you, Senator Harder, for your question. Yes, indeed, the resources dedicated to investigating ideologically motivated violent extremists have increased at CSIS. I would say that we are now close to 50% of our counterterrorism capacity devoted to that phenomenon, as opposed to the contrast to the phenomenon of religiously motivated. And it is indeed one of the concerns we have. We see both in Canada and across the world convergence of ideology and use of violence and Canada has not been immune to that. We have seen a number of terrorist attacks in Canada where people have lost their lives over the last number of years.
Merci. Le temps est écoulé.
Thank you. Time's up. Senator Campbell, 1 minute.
This is for Commissioner Luckey. Wellington Street is Ottawa PD. The Hill is your security responsibility. If it was such a high threat, can you advise why the RCMP-led PPS did not block off access to the Hill and only did so days after the EA was invoked?
Well, thank you for the question. First, the Parliament Hill is the responsibility of the parliamentary precinct. We do direct that, but that's their resources. The Wellington, like you said, is Ottawa Police Service, and so we were responsible for that area of the Parliament where we had blocked that off to the public and to the protesters in that area. The Wellington Street was the responsibility of Ottawa Police.
Thank you.
C'est fini, Mr. Campbell.
Done, Mr. Campbell. You had 2 seconds left. Good timing. Thank you to our witnesses for being here with us, and thank you to the panelists. We will be suspending a few moments for the next witness to arrive. Suspending.
Merci.
Minister. Good day. I'd like to welcome the Minister for Public Safety and his officials. You'll have 5 minutes for your opening statement. I'll give you an opportunity to start. I would say this. Your officials may be reinvited by the committee, Minister, so I would urge you to answer the questions that are asked of you yourself. Of course, if you need support, you, of course, can turn to them. Of course, we would prefer to use up the entire hour and a half that you're making available to us with you. Thank you. And I'm giving you the floor for 5 minutes for your introductory statement. Thank you, Mr. Chairman. Thank you to the committee. I'm very pleased to be here this evening with you. Of course, to discuss the emergency measures that was used for the first time in the history of our country. Along with me, I have my Deputy Minister, François Daigle, as well as Samantha Maitland-Dixon, Jennifer Dixon, and Heather Watts from the Department of Justice. They will be here to support me, as you've just said, on any technical questions, if need be. I'm quite pleased to be here with you in these traditional territories of the Anishinaabe Algonquin people.
February 14th, our government invoked the Emergencies Act, declaring a public order emergency pursuant to Part 2 of the Act. This was not a decision we took lightly, far from it. Cependant,
however, after consulting with leaders across the country, including the premiers of all provinces and territories, it became clear that the situation had exceeded their ability and authority to respond, and that other tools were required to protect the safety of Canada, of Canadians. From the outset, our government was very clear that the Emergencies Act was to be used only as long as it was deemed absolutely necessary, and that is why we have closely monitored and evaluated the situation to ensure that the measures taken remained required, reasonable, and proportionate. Thanks to the work of law enforcement agencies across the country, we were quickly able to announce on February 23rd that the situation was sufficiently under control so that we were able to repeal the declaration of the state of emergency and withdraw the measures that had been put in place as a result. The measures that were implemented were specifically tailored to meet the particular situation. The measures provided authorities with the additional tools they needed to deal with the emergency. These tools also deterred other illegal activities.
Summarize these specific and temporary measures. We temporarily prohibited participation in a public assembly that could reasonably be expected to lead to a breach of the peace and went beyond lawful protest. Police were temporarily able to secure places designated as protected, including Parliament Hill, critical infrastructure like airports, hospitals, and international border crossings. Police were temporarily given the ability to compel individuals and companies to provide the essential goods and services needed for removal, towing, and storage of any vehicles, equipment, structure, or other object that was a part of this blockade with reasonable compensation. Police were also able to temporarily refuse people traveling to the illegal protest with the intention of participating. In addition, there were these measures to temporarily prohibit bringing a minor to participate in such an assembly or entering Canada with the intent to participate in such an assembly, and to temporarily prohibit supporting an illegal assembly and giving the police the authority to enforce the prohibition by, for example, turning away people who were bringing in food, blankets, shelter materials to an area of an unlawful assembly. All of these temporary measures ended when we revoked the declaration of a public order emergency on February 23rd, 2022. They were in force for 9 days. Je prends au sérieux.
As Minister of Justice, I take seriously my responsibility to ensure that all government action is consistent with the Constitution, including the Charter of Rights and Freedoms. This includes all measures taken under the Emergencies Act. The Act itself provides that all temporary measures taken under the Act are consistent with the Charter, the Canadian Bill of Rights, and the international covenant on civil and political rights. This point is worth emphasizing because I think there's been some confusion. The measures employed under the Emergency Measures Act were reviewed for any inconsistency with the Charter. The government's position is that the measures taken are consistent with the Charter. Individual rights and freedoms were not suspended. The Charter continued to protect the rights and freedoms as the government had taken necessary, lawful, and proportionate measures to deal with illegal demonstrations and blockades.
Will always protect and defend the rights of Canadians to peaceful assembly and to express their views freely. But the blockades and occupation of downtown Ottawa were not peaceful assembly. The protests and blockades that we witnessed in February were illegal, intimidating, harassing, and a threat to Canada's security.
Monsieur le ministre, le temps est écoulé.
Minister, your time is up. I'm not sure if you can conclude in 2 seconds.
Je peux prendre vos questions. Donc.
I can take your questions. Thank you, Minister. First round of questions. Mr. Motz, do you have 5 minutes?
Ah, pardon, Monsieur.
Rather, Mr. Brock, 5 minutes.
Thank you, Mr. Chair, and good evening, Minister Lametti. Pleasure to have you present today. Thank you for that. I'm going to start off by looking at some of the earlier events that took place before the invocation of the Act. We know that the convoy itself declared a bunch of demands, and that was shared on social media quite extensively. They wanted to end all vaccine passports, including all inter-Canadian passports. They want to eliminate all mandatory programs of vaccination and contact tracing. They wanted rights of those who are vaccine-free to be respected. They wanted divisive rhetoric attacking Canadians who disagree with government mandates to stop at once, and to end all censorship of those with opinions contrary to the government. There is nothing in those public demands that would cause any federal government to have any concerns, because that is an expression of opinion as enshrined and protected by the Charter. Yes or no?
Thank you for the question, Mr. Brock. Indeed, there are statements that are protected by the Charter. What we're looking at here, though, were the actions that were taken, and that's what we focused on.
About actions, Minister?
Well, no, we can't distinguish the two.
Minister, you can distinguish that. I gave you a set of principles that the convoy protest indicated in their social media. My question is pointed, yes or no. What I repeated to you is constitutionally protected under the Charter, yes or no?
If they had stuck to those principles, we wouldn't be here.
I'm not asking that. Is it a yes or a no, sir?
They are constitutionally protected principles, but the actions were not.
Thank you. Now let's talk about the Memorandum of Understanding, or the manifesto. Is it your opinion today, as shared by the Prime Minister, as shared by other senior minister officials, that the manifesto itself called out for a violent overthrow of the Canadian government? Is that your understanding?
The manifesto itself was one indicator of the reasons that we took into consideration as we have tabled in the House of Commons. It was one factor that indicated amongst many other factors, including many actions, that forced us to take the measure.
And I'm not talking about other factors. I'm talking about the manifesto.
You can't distinguish them, Mr. Brock.
I can, because it's my question to you, Minister. The question is very simple. The manifesto itself, did you interpret that as a violent overthrow of the Canadian government?
I read the manifesto for the words that it contained, and as we did across the government, it was a factor that we considered amongst many other factors and many other actions.
I'll ask the question again, Minister.
Whether or
Did
not
you
to declare the
interpret that
Emergencies
as
Act.
a violent overthrow of the Canadian government?
Could the minister be allowed to answer the question?
He's not answering the question. That's the problem.
On va suspendre le temps, Monsieur Brock. Je vais juste
You'll suspend your time. Mr. Varani, you had a point of order?
Mrs. be allowed to answer the question. Thank you.
Alors,
Yes, Mr. Brock must allow the minister time to respond. I don't think he's preventing him from doing so, but I think he's trying to limit the answer. I'll allow Mr. Brock an opportunity to continue. Mr. Brock, you have 2 minutes left.
Minister, you may not like the question, you may not like the premise of the question, but the question is, Did you interpret, you as the head legal representative of the country of Canada, did you interpret that manifesto? And I'll repeat, the manifesto was to meet with the Governor General, then to meet with senators, and then to form a Canadian citizen group, then to take over the government. Did you view that as a violent insurrection against the Canadian government? Yes or no?
I took the manifesto for what it was, and I gave it the weight that it deserved.
Did you view that as a violent attempt to overthrow the Canadian government? For the fourth time now, Minister, will you answer the question?
It's a silly question. I took the manifesto for what it was,
Right.
and I gave it the weight that it deserved.
And the manifesto itself was silly, wasn't it?
No, I was referring to your question with all due respect. I took the manifesto for what it was, and I gave it the weight it deserved.
There was no guns found. There were no tanks brought to Wellington Street. No one stormed any Parliament buildings. There were no efforts to occupy any government building. Some called on the Prime Minister to resign, but there were no forms of force to try to make that happen. All under the manifesto.
Mr. Brock, there were guns found in Coutts, Alberta.
I'm not talking about Coutts. I'm talking about downtown Ottawa.
You have heard from other police officials that there were other threats across the
Minister,
country.
I'm talking about downtown Ottawa. I'm not talking about
Canada,
Coutts.
sir.
I'm talking about downtown Ottawa. That's my question.
I'm talking about Canada.
I'm talking about the Freedom Convoy here in the nation's capital, Ottawa.
I'm the Minister of Justice for the whole country.
I'm aware of that.
We took into consideration facts across the whole country. You have heard some of them. You have seen some of them published in our documents that we tabled in the House.
Time's up. Thank you, Minister. Thank you, Mr. Brock. Mr. Virani, 5 minutes.
Minister, you didn't have a chance to finish your response. We talked about statements were made, but actions were taken by people on the ground. What caused you, in terms of the actions taken by the people on the ground here in Ottawa, to consider it an unlawful act of dissent or unlawful protest?
Well, legal protest doesn't infringe on the rights of the people. Freedom of expression doesn't trench upon the rights of other people. This was well beyond freedom of expression. It was impeding the citizens of Ottawa from living their lives. It was impeding, as you heard from Minister Mendicino, businesses in Ottawa from going about their daily affairs. People were being harassed on the street, and it was basically slowing down the functioning of the city of Ottawa. That is well beyond, Mr. Virani, that was well beyond the limits of free speech. No right is unlimited. Every right is limited by the rights that other people have, and we had to take that into account as responsible legislators.
And the right, Minister, to lawful protest is specifically carved out in the regulations that were passed after the order was invoked. As I read it, it specifically talks about measures to regulate, prohibit, or any public assembly other than lawful advocacy, protest, or dissent. I presume you took it seriously to ensure that lawful protest in front of the House of Parliament for our national legislature was an important thing to protect.
Absolutely. We see it on Parliament Hill all the time. In fact, when the Ottawa Police, working in conjunction with a number of other police forces, cleared Wellington Street, the protests set up legally on sidewalks further down the street, and nobody bothered them. And they were allowed to make their point. That's legitimate free speech. That's legitimate protest. That's not what the situation on Wellington Street was, or on the Ambassador Bridge, or in Coutts, Alberta.
I would just add parenthetically that certainly no tanks were in existence, as Mr. Brock rightfully pointed out, but the only person to suggest the invocation of the Army was actually Senator Carignan in response to questions to Minister Mendicino, but I'll put that aside for a moment. Minister Lametti, when you're talking about charter compliance, when you talk about charter compliance, the hallmark of charter compliance is always proportionality. Looking at ensuring government action is minimally restrictive, it's targeted, it lasts no longer than necessary. Can you explain to the committee what steps were taken to ensure that the powers that were invoked were proportionate, and what informed the government's decision to revoke the declaration after a period of only 9 days?
Thank you, Mr. Virani. That's an excellent question. In general, every single measure we took had a specific goal in mind in terms of what we wanted to attain. They were measured, they were targeted, they were temporary, and they were proportionate. We made it clear that we would go no further than taking control of these situations across Canada. As soon as we didn't need the provisions anymore, we monitored the situation every single day and many times during every single day. As soon as those provisions were no longer needed, we revoked the Act. And the rights of Canadians, to the extent that they had been minimally impaired by these provisions, were now fully restored. We also made sure that we didn't impinge on other free speech rights, for example, other rights of assembly, for example, and other protests were happening across Canada in a legitimate way.
And what, in your view, there's obviously a legal test. You're the chief law officer of the Crown, so I think it's incumbent upon me to ask you this. Section 3 of the Act defines what is a national emergency. Section 16, 17 talk about what is a public order emergency. What, in your view, caused you to believe that the legal test was met under the statute for invoking a declaration of emergency?
Well, as we set out in the various documents that we tabled, we felt it was a national emergency under Section 3A of the Act because it seriously endangered Canadians and the safety and security of Canadians, exceeding the capacity of other authorities, the provinces in particular, to take care of it. And with respect to Section 3A of the Act, we needed measures. It was a situation of an urgent and critical nature, again, seriously endangering, exceeding capacity, and couldn't be dealt with under any other law. The context of the situation across Canada was such that we gave the police authorities additional powers to deal with the situation, to smooth over differences in jurisdiction, and to act to solve this threat. So it's always contextual, but it was clear to us that something needed to be done that was beyond the capacity of any one or a number of jurisdictions with the laws that they had. And the proof was in the pudding. It worked.
Thank you, Minister. And with respect...
Le temps est écoulé, monsieur.
Your time is up, Mr. Ronnie. I guess the minister knew. Mr. Green? I'll have the floor, so perhaps you can preside.
Minus, the floor is yours.
Monsieur le ministre.
Minister, thank you. Earlier on, with your colleague, Minister Mendicino, I asked the following question as to whether he had received any written advice before proclaiming the state of emergency. He said yes. I asked if it was in writing, and he said yes. Can you confirm whether you yourself have received some written advice yourself before the declaration? Mr. Fortin, as Minister of Justice, I myself issue advice to the Cabinet, and as Attorney General also. These are, my question was actually, had you received any? These are protected by, Minister, I'm not asking you if you issued any orders or advice, legal opinions, rather if you had received any. Mr. Fortin, such a statement from the Attorney General will be considered in some cases as a permission to do this. As the Attorney General, I have to rely on privilege. I understand that you did not receive any, but you issued some? Answer, Mr. Fortin, I cannot answer your question. Mr. Minister, you can't even tell me if you've issued it. Both people are speaking at the same time. Thank you, Minister. The other question is similar to the one I asked of the Minister of Public Safety. When you read the proclamation on emergency measures, there is an addendum. I'm sure you're aware of it. There's an obligation under the Act that states that the Governor of Canada in Council has to consult the premiers of the provinces and territories before declaring this. I think it's Section 25, says the Minister. Yes, and the summary of those consultations dated February 16th, 2022 is amended or is added to this proclamation, and without reading everything, on page 6, I see that the Premier of Quebec was opposed to the enforcement of the Emergency Measures Act. In fact, he said it was would be a source of division. The Premier of Alberta himself was opposed to invoking the Emergencies Act. The Premier of Saskatchewan was not in favor of it and said that the police had sufficient powers and tools to address this. The Premier of Manitoba stated that he was unconvinced that for the time being it was necessary to invoke it. Premiers of New Brunswick, Nova Scotia, and PEI said that it was not necessary in their provinces to invoke the Emergencies Act. The 3 territories' premiers had discussions with the Governor and Council, but did not issue any comments on invoking the Emergencies Act. So 7 provinces are against it. The 3 territories had no opinion or do not express any opinion on it. And there are 3 provinces who seem to have said, yes, we need this, or it would be a good idea to have this. What's the point of these consultations, Minister? As you know, because you've read the Act, Section 25, there is a duty to consult. But a unanimous view is not necessary. A majority is not even required. Question, but what's the point? Answer, consultation's always useful. Question, answer, there were consultations prior with the provinces, with police forces. Question, Minister, this is not my question. We don't have much time. Answer, I'm answering your question. My question. It is very difficult, says the minister, to really see what the premiers think. What's the point, though, if you're not paying attention to that? We were monitoring the situation in La Côte, in Quebec, in the city of Quebec. Question, Minister, you're saying it's important, but there are 7 provinces and 3 territories telling you no. And you make this proclamation. You state there's an emergency that is Canada-wide. How can you say it's important for you to take the pulse of things? You really didn't really take into account this. That's untrue. We were speaking on a constant basis with our counterparts, Mr. Fortin. Clearly, unanimity is brilliant. Mr. Mulroney had drafted this act. But it's not... It's the obligation of the federal government to take the necessary measures. We did what was required under the Act. We consulted pursuant to the Act. As you can read, and my time is up, Minister. Out of a sense of transparency, I just want to point that out.
Thank you. Mr. Fortin, the floor is back to you.
Merci, Monsieur Green. Merci, Monsieur le Ministre.
Thank you, Mr. Green. The floor is over to Mr. Green. 5 minutes.
Thank you very much, Mr. Chair. And I'll do the best that I can to put my questions through you. And I want to pick up on this notion of charter compliance because I think Canadians rightly deserve to know that the decisions that were made by government were proportional to the threat. And I believe that the challenge of this committee is to delve into the preconditions and the facts pertaining to what was before us. And we've heard, I think, very passionately a disagreement about the nature of the threat. I will go on the record and say that when an MOU of that nature is present, when the kind of open source evidence that is present on the internet talking about dropping bullets in our heads, when Coots has munitions found on site, I would take them at their word that they are a threat. But yet, given that, the declaration, the invocation in of itself was light on the language of or around the threat to national security under the CSIS Act. So my question through you, Mr. Chair, to the Honourable Attorney General is what facts or considerations did he provide in providing advice to the language of the invocation that would have considered Section 2, subsection D of the CSIS Act?
Thank you for the question, Mr. Green. You'll understand that, first of all, I'm constrained, first of all, by cabinet confidence, which is a fundamental principle of the Westminster system, as well as by solicitor-client privilege, which is also a fundamental principle according to our Supreme Court in our legal system. That being said, I'll answer your question in 2 ways. First of all, the document that we tabled goes through the nature of the various threats across the country, including some of the threats that you very rightly identified in the way that you framed your question. And these, we felt, met the question of serious threats to persons under the definition, under the CSIS Act definition, and primarily that. There is also the economic damage, which could be considered part of the property question.
Thank you for that. But more specifically, given that the national emergency, you've stated that there is a threat to person, but in Section B, under the application and construction of the Act, it talks about threatening the ability of the Government of Canada to preserve its sovereignty, security, and territorial integrity, and that cannot be effectively dealt with under any other law of Canada. When your colleague was before us, I put the questions noting the similarity in the language of the background document, under Section 1, which talked about activities that are directed towards or use the threat of serious acts of violence against persons or property on critical infrastructure for the purpose of achieving political or ideological objectives. That language is very similar to the language under the definition of terrorism under the Criminal Code, Section 83.1. So I guess when we're looking at objectively whether or not this could have been dealt with using any other laws in Canada, given the close nature in which you've identified ideologically motivated extremists, the infiltration of our security members, past and present, including the police, Joint Task Force 2, and the military, why was it not considered to use the definition of terrorism, given the weapons that were found in Coots and the MOU?
Thank you for that question. It's a good question. It's a complex question. Please let me answer it. Going down the road, the Criminal Code is a complex instrument. Each offense under the Criminal Code has its own mens rea component, has its own actus reus component. So a mental element and an active element, if you will. It doesn't help us to go down that road. Because they might carry with it, in order to be applied, they might carry with it other obligations on the part of police officer or whatever.
Is it through you, Mr. Chair, is it through you then the case that it was easier to invoke the Emergencies Act than it was to apply the strict high threshold of evidence under that language that seems to go between both definitions?
The Emergencies Act is I think, a well-crafted act. Again, it was brought in by the Mulroney government as a remedy to the old War Measures Act. And I think it's well crafted. It has in it a series of balances. It remains subject to the Charter, and it gives processes like these for further review.
So the last question is
let
on
me just
the
have one sentence, which is we tailored this act to the situation in order to be proportionate, in order to protect Canadians' rights.
Did you use the balance of probabilities, or did you use a threshold of beyond a reasonable doubt when you made those considerations?
We used the threshold elaborated in the act. In Section 3, in Section 16, and in Section 2.
Time's up.
Merci, Monsieur le Ministre.
Thank you, Minister. Senator Boniface, you have 5 minutes.
Welcome, Minister, and thank you for being here. I'd like to talk a little bit about talking about Ottawa and the injunction, and I'd just like to have a sense of what you saw as the importance, if there was any importance, to the multitude of complaints from citizens of Ottawa. And like many people here, when I stay here during the week, I run into neighbors, and the neighbors have certainly filled me in on how they viewed this and the way it was handled. But there was an injunction that was filed, which by an individual, as you know, which banned the noise pollution emanated from the trucks and other conveyances. How did that play into the decision-making around the declaration of emergency? Because the question I get, so just to give you a chance in the fullness of, question I get is, why did an individual have to take the injunction when, in fact, you got 3 levels of government that could have done the same thing and perhaps had a lot more to work with?
Thank you, Senator Boniface. I too live in Ottawa much of the week, and so was living with this as well. And my office was right on Wellington. The injunction was I won't comment on the substance of the injunction, other than to say that it is a private law remedy that's being used by a private individual, and nothing in what we do precludes private individuals from taking private law remedies. As government, we have public law remedies. The Emergencies Act is one of them, and that is what we chose to use because we felt it was necessary. All of the citizen complaints, if you will, putting it that way, are evidence that that their rights were being infringed upon in a very serious way by the illegal activity of the convoy.
So it would have been taken into consideration. I guess I'm just trying to get the heart of the question on why would not one of the levels of government looked at an injunction as one of the options and prior to getting to a declaration?
We don't use injunctions as a private law remedy as a government. We use other direct public law means, criminal code, other statutes, in this case the Emergencies Act. So it's a different basket. I mean, I taught in a law faculty for 25 years, so 20 years. So if you taught private law, you looked at injunctions. This isn't part of the toolkit that governments use because we have other tools.
Okay, well, we'll disagree on that because I've actually been involved in one where an injunction was used in this situation. So how that's used, I just think that there is a view of the public out there that says, why did this individual have to do this on their own? And I'm not saying necessarily it should have been the federal government, the provincial government, municipal. I'm just asking, as we move forward, is this something this committee should consider? How injunction may have assisted in this type of situation.
Well, we did intervene in support of that injunction,
Yes.
but it's still a private law remedy.
Right. Okay. Thank you. And so it would also be interesting for me, going back to the point you made in your opening comments on the issue of part of your restrictions around coming for people coming to Canada for the purpose of the protests or such like. I assume then that there is some evidence that suggested that we may have had people who were interested in coming across the border from, I would assume, the United States to participate in the protests, and that would be why you would put that in specifically?
That's correct. That's in the public domain. That people were. There were reports of people crossing the border. There were reports. CBC reported, I believe, on the 14th of February, or the 13th of February, that there was also foreign funding through a variety of different sites. So that the various pieces of information that we had explained the various measures that we took.
Okay, and the final question, and this is when we asked your colleague, Minister Mendocino, to try to get a sense of at what point in the time frame of the protest that it moved from a lawful demonstration to an illegal occupation. How would that align with your declaration of emergency?
Well, the idea that it went past limits, I think it's fair to say that people were making those kinds of arguments right from the get-go, whether it was the Ambassador Bridge, whether it was Coots, whether it was Emerson, whether it was threats in other places. The question for us with the Emergencies Act is an entirely different question, which is, at what point is it clear to us as a federal government that the situation has now moved beyond the ability of the province?
Le temps est écoulé.
Your time is up. Thank you, Senator. Thank you, Minister. Senator Carignan, you have the floor, 5 minutes. Thank you, Mr. Chair. Minister, good evening. I understand that you're the Minister of Justice, Solicitor General, and you provide legal opinion to the Government of Canada. That is part of my responsibilities, yes. I'm going to read something from Mr. Beattie, the sponsor of the bill in second reading, in 1987 in the House of Commons in November on C-77. I quote, "Unlike the War Measures Act, Part 2 of the bill does not confer upon the government any additional powers with respect to search, seizure, arrest, or detention. We believe the criminal code provisions are enough to maintain order." End quote. Minister, how can you say that it is consistent with the Charter to seize bank accounts without any legislative foundation for that, without any search warrant, the only purpose being to scare people, tell me that that is consistent with Section 8 of the Charter of Rights and Freedom. Thank you, Senator, for your question. I do not share your interpretation of the facts. First off, there was no seizure in this case. There were accounts that were managed, but there was no seizure. Question inaudible. It was temporary. Okay, even 1 hour is not seizure? It was during the period that the person took part in an illegal protest, illegal activity. We did it for individuals who, we do it in the case of tax evasion, we do it in the case of question. You have the power. Answer. Two people are speaking at the same time. The father of this act says that this act does not have the power to do this. With respect, Senator, I know Mr. Beattie very well. He was a wonderful man, but he could not predict any and every future occurrence. So we took the act as it was drafted by Mr. Beattie and Mr. Mulroney, and we enforced it applied it in a reasonable and specific way. The Emergencies Act does not give you the power to do searches and seizures. You froze bank accounts. That's a seizure. I think I would urge you to read the jurisprudence. You're a brilliant lawyer. You know how to read this case law. I'm certain that the courts will find that we are right. Well, if the government of Canada were to consult me as a lawyer and said, I have a lawyer who tells me that to seize a bank account, freezing a bank account with no warrant, with no legislative authority to do so, that is consistent with the Charter, I would say you better change lawyers. I would say me too if you were to provide that answer. We had legislation. We had an act. We had powers under the act. There were no seizures. There were specific measures that were temporary. What was your purpose by freezing these bank accounts? To cut the funding of this. Actually, so you wanted to cut. You understand, Senator, it was to cut the source of funding for these illegal protests. Senators, do you believe... Two people are speaking at the same time. Do you think tax evasion is illegal? Because we take the same measures for that. I guess that if the source was not that was not that concerning, if you unblock the freeze. We said we would maintain the measures so long as they were necessary, but you froze and then unfroze these bank accounts. The protests were illegal. When they're no longer there, the protests, then we revoked the act and we unfroze these sources. Minister, you said the sources of funds were illegal. Why did you unfreeze these accounts? Mr. Carignan, you're putting words in my mouth here. We wanted to stop the flow of funding for illegal funding and illegal activity. That's clear in the Act, and it's clear in my answer. Thank you, Minister.
Monsieur Cavignon.
Point of order.
Pardon?
Point of order. Point of order.
J'entends point of order.
Point of règlement.
Ah, OK.
Practicing my French, and in defense of the French language, I just want to note that I'm finding the translators are having a difficult time when people are speaking over each other. And I just, and I know I'm guilty of it too, but I just want to put to the members that, they're working hard late into the night here. We want to give them the ability to do
I would
their
just
job
say welcome to the club, Mr. Green.
so that we can hear it. This is why I'm here.
I'm always on translation.
Let it be on the record that I'm here defending the Francophone rights. Thank you.
Merci, Monsieur Green.
Thank you, Mr. Green. Indeed, we will try to be careful with that. I understand your point. Now, Senator Harder, 5 minutes.
Thank you, Mr. Fortin. Minister, I'd like to follow up on Senator Boniface's questions. If you could describe your thinking and the advice that you were giving the government in the 3 weeks before the invocation of the Act, at what point did you feel that the invocation of the Act was not only the only but the best choice available to the government. And as I asked your colleague, Mr. Mendicino, why did it take 24 days?
Thank you for the question, Senator Harder. It was an unprecedented situation, and obviously I will not divulge cabinet confidence. You're well aware of that, nor will I divulge or betray solicitor-client privilege. That being said, we watched the situation. We watched it evolve. We watched authorities try to deal with the situation with the tools that they had in hand. We consulted all the way through, as my colleague Marco Mendicino pointed out. Consulted police forces. We consulted governments. We had letters from ministers from other provinces, from Alberta, for example, saying we need tow trucks. We can't handle this. So we were taking all of this in. We invoked the Emergencies Act when it became clear to us that, first of all, the situation was national in scope, that we had met the threshold definitions under the Act, and that the provinces or other local authorities were not capable of handling it on their own.
Thank you. Earlier in your testimony, you enumerated the powers that the Emergency Act provided. Can you inform us as to from whom the pieces of consultation derived from with respect to those enumerated powers? I presume that they weren't just in the Department of Justice or even in the federal government. What level of consultation were there with other jurisdictions that you are aware of?
There was continual consultation with other jurisdictions and other police forces, both directly to people around the table, but also through Commissioner Lucky and other officials. So there was continual. And so the ideas that came up were specific tools that were identified. We needed tow trucks. There was simply a resistance amongst tow truck operators to participate. When the Act came into force, magically they appeared. Same thing with respect to financing. We saw that there was a need to try to attack the sources of financing of this illegal activity. And so the financing measures came into place.
In those consultations, did you consult with provincial attorneys general?
There were. We did have a consultation report. There were. Again, I'm not going to betray. Cabinet confidences, but in particular, as you see from the report, the Minister of Public Safety and the Minister of Emergency Preparedness were probably the two that were out with doing the most consultations. Yes.
Final question. In your statement, you said, quote, we monitored every day. The we, I'd like you to describe who the we is, because I would presume that it's not just ministers of the Government of Canada.
Well, you will see in the report that we tabled in Parliament that there was an incident response group that included ministers, but also included the Commissioner of the RCMP. It also included public safety, public security, and national security officials.
And when the invocation was revoked, my understanding is that was done immediately after the advice was received by the government from that response team. Is that correct?
I'm not going to betray cabinet confidence, but we have said publicly, I have said this evening, my colleague has said this evening that we would not leave it in place a minute longer than necessary.
2 minutes, maybe.
But you can draw your own conclusions.
Thank you.
Merci, Monsieur.
Thank you, Senator Harder. Senator Campbell, you have 5 minutes.
Thank you, Chair, and thank you for coming today. There are now 2 government bodies looking into the Emergency Act. There's this body and there's an inquiry that has been announced. My question is, how does this committee affect the recently announced Emergency Act inquiry? How do they come together or not come together?
Thank you for the question, Senator. It's a good one. Both of these institutions are envisaged in the Act itself. So both the parliamentary committee as well as the independent inquiry. It's not a government inquiry. It is an inquiry under the Inquiries Act, and it is completely independent. The Commission's mandate, and I'll read it, the circumstances that look into the circumstances that led to the declaration being issued, etc., extending to the extent relevant circumstances and measures are taken, the evolution goals, the whole context, including role of domestic foreign funding, crowdsourcing, etc. It's a very, very wide mandate that the independent inquiry has. My understanding is that the Parliamentary Review Committee is meant to review what we did as a government with respect to the invocation of the Emergencies Act. There will necessarily be some overlap, but I believe, at least the way I read the mandates in the Act, the independent inquiry is probably wider, and he probably has, under the Inquiries Act, additional powers as well.
Do you see them as complementary or oppositional?
Very much complementary. I take that in the spirit of the Act that Mr. Mulroney and Mr. Beattie passed. I think they both have a relevant role. It's why I'm here, frankly, enthusiastically. I don't necessarily agree with all of the questions that are asked or the framing, but I'm here because we have a duty to report. And when we deliberated, we knew that we had a duty to report, and we took that seriously in our deliberations to invoke the Act.
Thank you very much, Chair.
Merci, Monsieur.
Thank you, Mr. Campbell. Now we're on to the second round of questions. The questions go to Mr. Brock, correct? Or Mr. Motz? Mr. Motz, 4 minutes.
Thank you very much, Chair, and thank you, Minister, for being here. You know, you had just finished talking about the duty that you have, and I think I would be remiss not to remind that we all have a duty, including yourself, sir, to be fully transparent and accountable to the Canadian public, and that's one of the reasons why we're having this review, as well as the inquiry, I would suggest. And so, you know, I think it's important that Canadians can trust that when we ask for information, that information can be made available. I know it's easy to hide behind cabinet confidence, but that doesn't give Canadian public confidence, and it really doesn't. They have to have reason to trust this government, and they have to have reason to trust this committee, that we have full access to the information that the government relied upon to make those decisions. And it's fair that we do. And I would ask that you undertake to provide the analysis and the information that you were made aware of, that you relied upon to be part of making the invocation for this particular Emergencies Act, sir.
Thank you, Mr. Motz. I understand the sentiment behind the question, and I certainly share the goal of transparency. I think Canadians will understand that cabinet confidence is a critical part of our cabinet governance system. The ability for members around the cabinet table to be able to express their opinions freely, particularly when they disagree, particularly when they have to leave that room and all give a common answer, which they may not have disagreed with, which they may not have agreed with privately. That's a critical part of our system, and so the waiving of cabinet confidence is extremely rare. We have, and the same is true for solicitor-client privilege, we have given a detailed map in the documents that we have tabled. We have tabled our consultation report. We have tabled the reasons for which we invoked the Act, and we feel we've met the Act. So we've effectively given the conclusions
fair enough.
of the discussions.
Okay, thank you. I appreciate the position you've taken. I think we have to also recognize the supremacy of Parliament, and that was something that I'm sure will come forward in the future. But based on your testimony tonight, sir, I think it appears as if on a comment you made, I believe, to Senator Boniface, that you went straight to the Emergencies Act, contrary to Section 3 of the Emergencies Act, that requires the situation that cannot be properly handled, effectively handled under any other law in Canada. And I would suggest that there is many sections in the Criminal Code, too numerous to mention in my limited time, and certainly provincial statutes and municipal bylaws could even have been employed, and they either were not fully or properly utilized in this situation, and that's what may have prompted you to do that. And I want to get to a question that Mr. Green asked about the charter. Now, many Canadians believe that the order in council by this particular, in this particular situation raised serious concerns with respect to charter rights. Section 2 guarantees freedom of association and assembly. Section 7, the right to liberty and freedom and security of the person. Section 8 guarantees protection against unreasonable search and seizure. And I guess my question to you is, and again, it was mentioned before, that judges have ruled previously on the limitation of our fundamental freedoms must be demonstrably justified, reasonably proportionate, and prescribed by law. Now, did you conduct a full charter review, sir, and compliance review in all aspects of this particular act? And if so, whom did you consult with? And are you able to share those findings with the committee?
In 5 seconds.
With your premise that we went straight to the Emergencies Act. We did not invoke it before we felt it was absolutely necessary. With respect to the
Merci,
charter,
Monsieur le Ministre.
Thank you, Minister. Unfortunately, your time is up. I give you an extra 15 seconds grace, but...
Okay, Mr. Green will take up your question.
Oui.
Okay.
Merci, Monsieur le Ministre.
Thank you, Minister.
Monsieur Birani ou Monsieur...
Mr. Nakfi or Mr. Nakfi, you have the floor, 4 minutes.
Merci beaucoup, President. Attorney, good to see you. Let me go to the issue, the question around the charter. But first and foremost, can you highlight to us the difference between the Emergencies Act and its predecessor, the War Measures Act?
They are two entirely different animals. The War Measures Act allowed for the complete suspension of rights. The Emergencies Act does not do that. Rights continue to subsist. The Charter continues to apply. We have the duty to be here in front of you to explain what we've done. We have the duty to have a public inquiry. We have a duty to table certain documents. None of that was present under the War Measures Act. The War Measures Act was much more authoritarian, and I have said this publicly tonight, and I'll say it again, that I thought that the changes brought by Mr. Mulroney were very balanced, and Mr. Beattie, and we have applied those. With respect to the Charter, no rights are unlimited. No rights are unlimited. There's a balancing provision within the Charter, Article 1 of the Section 1 of the Charter, and we were targeting illegal activity. We were targeting unlawful protest. We weren't targeting lawful protest. We weren't targeting freedom of speech. Freedom of speech that people had never was restricted. Only blocking bridges, City of Ottawa, threatening in other places. That's the kind of activity we were targeting very specifically.
And that targeting takes place on the basis of the facts that you have in front of you, such as in this case, the illegal occupation and peaceful assembly here in Ottawa and the blockades of border crossings.
That's correct. I mean, anybody who thinks that the assembly here in Ottawa was peaceful didn't really see it up close.
I want to very quickly check with you. There was a line of questioning to you, I think, from Senator Carillon around the power to seize frozen bank accounts. That power comes straight from the Emergencies Act under Section 19(1), where it says you can have regulations prohibiting the use of specified property.
That's correct.
That's where you derived that authority?
We didn't actually seize property. This is the distinction that where I disagreed with the interpretation of Senator Carignan. We temporarily froze for as long as the illegal activity which those funds were supporting, directly or indirectly, was maintained. As soon as the activity ended, the accounts were unfrozen, and we did not keep any property. We did not seize any property at any time.
Time limited and proportional was the test that you used.
That is correct. Only meant to impede the support of illegal activity.
Minister Mendocino said in his opening remarks that the government was reluctant to invoke and eager to revoke the emergency order. Do you agree with that sentiment?
Very much so. I mean, when you get appointed Minister of Justice and Attorney General, you don't think you're going to be the first Minister of Justice and Attorney General to invoke the Emergencies Act. So believe me, you hesitate. You are careful. You make sure that it is it's a last resort. And you make sure that it is, well, it's the second last resort. The last resort is the Army. And I was as shocked as others were to hear that Senator Carignan wanted to bring in the Army. But we did not want to bring in the Army. And I am proud that we did not bring in the Army. And I am proud that we resolved this situation without injury, that we resolved it peacefully. And I'm very, very proud of that.
Thank you, Attorney.
Merci, Monsieur Neg.
Thank you, Mr. Nakvi. Thank you, Minister. Mr. Green, it will be my turn again. I'll ask you to chair the meeting.
The floor is yours.
Merci.
Thank you, Minister. I'm hearing your testimony, and I also find that the situation was deplorable. What happened on the Hill? What was happening on the Hill was it just made no sense. What happened on Wellington Street specifically. But I'm having a hard time understanding how the situation was allowed to degenerate to that extent. If someone had told me a year ago that you could basically set up barbecues and jacuzzis and park your truck on Wellington Street, I would have said that's ridiculous, that's impossible, but that's exactly what happened. When I hear that the Emergencies Act had to be invoked, I'm concerned. Are you of the view that we're in the same situation as before, that essentially if someone were to show up over the weekend and decided to blockade or set up a blockade on Wellington or elsewhere in Ottawa or on Parliament Hill, we would still be at the mercy of this, and then we would again have to invoke the Emergencies Act? Or could measures be taken based on current legislation, whether it's the Criminal Code, the Highway Traffic Act, or something else? That's a good question, Mr. Fortin. I'm not going to presume what police forces would do. They have tools at their disposal. We provided with the Act further tools if there were to be situations in the future or tools in the criminal code tools and other legal instruments would not be useful, then we would have to reconsider the Emergency Act. Question. But the right to tow vehicles is in the Highway Traffic Act. You know this as well as I do, better than me, actually. The powers that police officers have, arresting people who are causing a disturbance and the rest. How can you state that you needed further additional powers? To me, it seems that everything that was done really could have been done with the tools available. In speaking to police forces throughout Canada, speaking to our colleagues throughout Canada, we found ourselves in a situation where the facts were that tow trucks were not available. We took the measures that were required. In all of Canada, there were no tow trucks available to come to Parliament Hill. You're concerned. I'm even more concerned. You heard Madam Lucky and others say that the announcement of the emergency measures, the Emergencies Act, was a positive on the street. Sure, it was positive, but couldn't we have solved this problem without?
On a réglé la situation.
The situation was solved. I hope it will not be necessary in the future.
Minister.
Thank you, Minister. Mr. Green, you have the floor. 3 minutes.
Thank you. Much has been said about the need for us to have transparency and accountability throughout this process, and yet we've heard in early testimony and comments in the media a constant reference to cabinet confidentiality and solicitor-client privilege. And I think, there's an opportunity here for us to provide Canadians on both sides of the issue the clarity that they need. So I'm not asking you to waive cabinet confidentiality, but I do have questions of specificity around charter compliance. Within the Department of Justice, through you, Mr. Chair, to the Attorney General, would you have staff dedicated to charter breach analysis?
Yes.
Okay, so on what factual basis for each of the objective elements that was considered, the 6 types of temporary measures that you invoked, on what factual basis for each of these objective elements was considered to show that the charter breaches were saved under Section 1?
Look, I can't go into detail.
Why?
because that's the listener-client privilege.
So through you, Mr. Chair, will it not be the case that there, in a high likelihood, given the Canadian Civil Liberties Association's impending legal action, will there be a scenario in that legal action where you may be compelled to testify on providing Canadians with answers on the factual basis? And we've heard this from the Liberal side time and time again, that these decisions were made on the basis of facts. This committee is an important committee. Will you, in this moment, provide us with clarity on the factual basis for which the objective elements were met on the 6 temporary measures?
I have given, and I have given what are in effect the conclusions that we have reached as a result of the charter analyses that we did in each case. With respect to litigation upcoming, I'm glad you raised that, because that's sadly another form of privilege, which is litigation privilege. We will make arguments in court. The Attorney General will make arguments in court in those cases. I think we will prevail in those cases, but you will see those arguments when we make them. I will not impede our arguments by giving those arguments
Well,
now.
perhaps not impeding the arguments, but you're certainly impeding the process through which we can get clarity. There's an opportunity amongst us right now, within this committee, whether it's at this meeting or the next, to just be honest with Canadians about the evidence and the facts pertaining to the measures that you chose, right? And I think what's frustrating in this process is that I'm of the opinion that, and I supported this, that much was missed in the analysis in terms of the threat of national security under subsection D of the CSIS Act. I take them at their word. And also, quite frankly, the ability of the government to communicate clearly to Canadians about what the actual facts were. So, you know, there's going to be lots of debates around this table, Mr. Chair, in these upcoming weeks and months. And there's going to be motions to provide, information. We're sworn in this special committee. And I would just put to the minister in close that he consider, given what's at stake here, to be more cooperative with this committee and forthcoming on the facts.
Merci, Monsieur Green.
Thank you, Mr. Green. I'd like to answer the question briefly. You have 5 seconds, Mr.
As Attorney General, I also have a duty to protect solicitor-client privilege, which enables Canadians, not just in government, but Canadians across Canada, to get good, honest legal advice, even when it's not what they want to hear. And that's a virtue as well. Obviously, I will continue to work with you to build that trust. I'll continue to work with Canadians to build that trust. But Canadians, I think, will understand that as Attorney General, I have to protect that privilege.
Merci, Monsieur le Ministre.
Thank you, Minister. Mr. Carignan, you have 3 minutes. Thank you, Mr. Chairman. Minister, I would like to keep going with the questions, the line of questioning from earlier. We were talking about the sources of financing. When you seized the bank accounts, it wasn't because the money was coming from illegal sources. Your purpose was to prevent people using their money to pay for their trucks or use their debit card to buy food or gas on Wellington Street. Mr. Carignan, as I said, we did not seize anything. You can say that if you want to, but that's not the case. We wanted to prevent there being support for illegal activity, directly or indirectly, either through a truck or through financial means. These are things that we do elsewhere to combat terrorism, to fight tax evasion. These are known tools under our legislation, and we applied them in these circumstances, and it worked. Yeah, sure, it worked. It worked. Look, you can kill a fly with a fly swatter or with a tank, but there might be a question of proportionality here. I think it was quite proportional. The funds were frozen. We didn't seize anything. This property would... Yes, but you said people could not take money out of the bank, and at no point when the money wasn't... I said when illegal activity stopped, then these accounts were unfrozen. And you think this complies with the charter? It's targeted, it's measured. This is something that we employ elsewhere with legislation that authorized it. there was legislation here that authorized it, the Emergencies Act. You interpret the act as saying it authorizes search and seizure. Okay, we must not be reading the same act. There's no seizure. As two people speaking at the same time. Aside from cutting people's sources of revenue, aside from the fact that the Emergencies Act allowed you to find tow trucks, you were unable to find them. So you were able to find these tow trucks. What other additional powers did you get thanks to the Emergencies Act? First of all, we designated spaces like bridges, critical infrastructure, Parliament, to prevent illegal activity and protests there from happening. And that is a question Senator Boniface was asking. Your time is up, says the chair. We did not take away police powers, but we facilitated the RCMP's activities in police operation. Thank you, Minister. Senator Boniface, you have 3 minutes.
Thank you very much. And Minister, thank you for clarifying on the injunction, because I think it's a question that many people asked on. So I just wanted to loop back to it. I think it's better understood both by me and by the members of the public who may be watching. With respect to the tow trucks, because this question has come up, and I know it's not, Minister Mendocino would have been him, but we are not talking about one tow truck to tow one truck. We had, I don't know the exact number, but I know I read somewhere 60 to 70 trucks in there that at some point.
And specialized trucks and drivers.
Specialized trucks, which means specialized tow trucks. I just want to be clear because I don't want it to perceive that it was on a whim by the request from the police with respect to that. And I'm assuming the request came from the police. The second point I wanted to ask you on is when you look at the Act now, drafted in 1988, do you see that successive governments, have missed an opportunity to review the Act in a way that would make it less of a blunt instrument, or that there should have been changes done within the intervening years?
Can you ask me that in another couple of years? And no, and I mean that. I do hope that the work that you do, I do hope that the work that the independent inquiry will accomplish will help push us towards a reform of the law. To be honest, I'm still too much in the middle of it. I may have some opinions. I'm not ready to share them yet. I would like to see the fullness of the report come out. But I do believe, I think that we do have an obligation as legislators to continue to tweak and to reform wholesale if that's what we have to do. The Mulroney reform was wholesale, and it was a good reform, right, from the old War Measures Act to this. There may be tweaking here that needs to be done. I'd rather not comment now. That's for the future, but I think it's a very, very good question you're asking.
Okay, thank you. And because I'm hoping, because I know the province of Ontario is moving with some legislative change for theirs, and I'm hoping at some point somebody's going to look at the relationship between a provincial order of emergency and this act and determine whether or not we have gaps in between that are left open to interpretation, and I think the more we clarify, the better. The final thing I wanted to mention was, and ask the question around, would you be agreeable to, the Canadian Police Association has been visiting various people and suggesting there needs to be a national summit that would bring together key stakeholders to talk about how protests should be policed and how those resources are accessed and how that should become. I would think that the federal government would find themselves in a position to be a good convener of this, given the levels of...
Votre temps est écoulé, Madame.
Your time is up, Senator.
Just briefly, Monsieur le Président, brièvement.
5 secondes.
I think, I don't want to speak for my colleagues Mendocino and Blair, but I think we would be amenable to that.
Merci, Monsieur le Ministre.
Thank you, Minister. Thank you, Senator. We have 15 minutes left. Again, I would propose that we do what we did in the first part of the meeting with the Minister for Public Safety. In other words, each speaker in the first round would get 1 minute. Does that work? Any objections?
Le Président, comme vous.
Yes, a minute is not much. Yes, but I have a hard time dividing a minute. Listen, if you say a minute 15 seconds, I'm not sure.
Comme on a convenu,
As we determined in the second round, not all 4 senators, so just 2 senators and 2 minutes.
J'aime beaucoup vos questions sur l'armée, Monsieur Carignan.
I love your questions on the Army, Mr. Carignan, but I completely disagree with you.
Je peux pas.
Time is running, and I can't really stop it as we keep talking, but senators, would you agree that only 2 of you get a speaking round in the third round? So in other words, 2 minutes each? Instead of 4 senators, only 2 senators would get 2 minutes. Is that all right?
Une minute pour tout le monde.
A minute each. There doesn't seem to be unanimous consent. No problem. Let's go ahead with 1 minute. I understand it would be wise to find another system, but I just can't come up with that right now. Mr. Brock, 1 minute.
Minister, one question, 4 parts. You chose Justice Rouleau to head the so-called independent inquiry. I know the justice through my former legal circles. I also know he was a senior Liberal PMO staffer before he went to the bench. Was his Liberal pedigree essential to his selection or merely a bonus? Can you help us understand how you how you came to choose Justice Rouleau? How many justices were consulted before you chose Justice Rouleau, and how many declined that opportunity?
The process was to my understanding, undertaken by the Privy Council Office. Let me just say that judges who are appointed of whatever political stripe, plenty were appointed by Conservatives, plenty have been appointed by Liberals, do their job to the best of their abilities in a neutral fashion. We have an outstanding judiciary in Canada. I would be proud. I'm proud that Justice Rouleau is taking part of this. I'd be proud for a number of judges.
Le temps est écoulé. Merci.
Your time is up, Minister. Thank you, Minister. Thank you, Mr. Brock. Mr. Varani, Ms. Bendayan. Ms. Bendayan, 1 minute.
Thank you, Minister. Given the short amount of time, I'll go very quickly. We've been discussing the Charter at length. I would like to bring you to Section 7 of the Charter and the importance of our right to liberty as Canadians. And I would like to put to you that it was necessary in order to protect the freedom of Canadians and the liberty of Canadians to move about freely within their city, within the city of Ottawa, to move about freely and attend their place of work in Coutts, Alberta, Emerson, Manitoba, Surrey, British Columbia, and elsewhere right across the country. Was the Emergency Act necessary in order to protect those Canadians' charters' rights?
Absolutely, yes.
Thank you, Minister. I would also like to take you to the point of restraint, which you mentioned earlier. I understand that we did not designate additional places under the Emergencies Act, but is it true that we did have to designate the War Memorial due to the desecration and of men and women actually urinating on the War Memorial? Was it necessary to invoke the Emergencies Act in order to protect the War Memorial?
Sadly, yes. It's a matter of public record.
And, Minister, to clarify on the record, is it your opinion as Attorney General
Your time is up, Ms. Bendayan.
that the test was met in order to invoke the Emergencies Act as
Merci,
outlined?
Madame Bendayan.
Thank you, Ms. Bendayan. Thank you. My turn again, Mr. Green.
Yep. Monsieur le ministre.
Minister, in your testimony earlier, you said there were consultations here that we find attached to this document. It's prior to Article 25.1, and then we talk about provinces going through emergencies. Regardless, it's here, but you said you had other consultations. You say that you were constantly in consultations with the provinces on the question of the situation that we are addressing here. Since when, as of what date did you start these consultations with the premiers or attorneys general of the provinces? The record of the consultations was tabled in Parliament. As you've noticed, what you mean the record, you mean the amendments? I spoke to my counterpart in Quebec the night that the act was proclaimed. We have consultations throughout the country. Sorry, my time is up, Minister.
Thank you, Mr. You have the floor back.
Monsieur Green.
Mr. Green, 1 minute.
Thank you very much. We've heard around the table that the authorities were insufficient for local police and indeed provincial police across the country to be able to adequately deal with that. And yet there's been, I think, open source evidence that it wasn't necessarily insufficient authorities, but authorities who were insufficient. And so my question through you to the honourable member is, does he believe that if the police had simply acted with the authority in which they'd already granted, i.e. taking early advice from ITAC, understanding the information that was given to them as it relates to a national security threat, and acted in accordance with that information, could we have avoided this situation to begin with?
As a legislator, as a member of parliament, as the Attorney General, I was part of a group that had to deal with facts on the ground. So I'm not going to speculate on what police might or might not have done. My role, given the facts on the ground, was to try to give...
Ground, Mr. Chair, was that the police failed to act within the city of Ottawa for 3 weeks.
I'm only going to...
Your time is up.
Buddy, in this forum,
Your time is up.
Peut-être que Madame la sénatrice... Je sais...
This is a very important question. Yes, of course, Minister, but everyone has important questions. We're all frustrated. You don't always answer every question. We would need the entire evening. This is so important, but unfortunately, that is not the case, and my job is to manage the time. Senator Boniface, 1 minute.
I want to follow up on Mr. Green's comments because as you would expect, I may disagree with his assumptions around what police did and didn't do because we don't know the facts of exactly what they were faced with as a time. And I think that will be part of what we will hear, will we not? I expect we will hear from the chiefs and such like. I think your point was, and I just want to make sure, clarify, your point was you dealt with the facts you had at the time, that when the police came to you and indicated that they needed certain powers in order to do the job that needed to be done to meet the needs of the city of Ottawa. Is that not correct?
That's correct. The facts for me, as someone who had to try to deal with it from the position of the cabinet meetings, incident response group, was dealing with the facts on the ground.
Thank you.
And that's all I did.
Merci, Madame la sénatrice.
Thank you, Senators. Senator Carignan, 1 minute. Yes, thank you, Minister. You're aware of Section 134.1 of the Highway Traffic Act of Ontario. You've heard my question. I don't have it here before me, but it's not important. I'll read it quickly, and it's very important. Any police officer who believes it is reasonably necessary to maintain order, traffic, can remove or require that any vehicle be towed if it is blocking traffic, etc. Police officers already had that power under the Highway Traffic Act to tow vehicles, to remove that spa, that barbecue, remove those tents, etc., the jacuzzi. In what way the Emergencies Act helped or did more than that? I've already described what we did under the Act to respond to the circumstances at hand. That's what was required as a government. That's what we did, and we managed this very well. Question, does it require to use this Emergencies Act to tow vehicles? We had far more than that. Thank you, Minister. Senator Harder, 1 minute.
Thank you, Chair, and thank you, Minister. Minister, I premised my question by saying I fully understand and agree with Cabinet confidence and with client solicitor privilege. But I want to talk about charter compliance and vehicles that the government does use to assure parliamentarians of compliance. When we have individual bills, the Minister of Justice tables a charter compliance. I wonder if you would contemplate tabling with this committee a statement of charter compliance.
Well, thank you for the question, Senator Harder. It is true that under the, and I've forgotten the measure, I am not required, because this is not a bill, to table a certificate of charter compliance. That being said, I am required by the law under the, I believe, the Statutory Interpretation Act or something like that, 4.2 of that act, to make sure that it is compliant with the charter. And I have given you the conclusions that I have come to, that what we have done is charter compliant.
Merci, Monsieur le Ministre.
Thank you, Minister. Our time is up. And now on to the final member, Senator Campbell, 1 minute.
Thank you very much. Minister, would you consider through the FTP process looking at emergency laws across Canada and how they fit together?
I think, again, as a question, when your work is done, when the inquiry work is done, I would certainly consider that.
Thank you. Thank you.
Merci, monsieur.
Thank you, Mr. Campbell. Minister, thank you very much. I understand your frustration. You know, what I've learned from taking part in the work of the House and committees, what I'm hearing and what I'm learning actually through this work is to manage my frustration. Actually, we're almost happy sometimes to see that even ministers can be somewhat frustrated by this. There's so little time, so much to do. There was a thought.
On pourrait vous réinviter, monsieur.
We could reinvite you, Minister. I'm sure everyone around this table would agree to you being reinvited if you were willing to continue this discussion. It would always be useful.
Before you wrap up, if I could.
Oui, point d'ordre, Monsieur Green.
Just a general practice that we've had at this committee is to invite the witnesses to provide in writing any additional comments on questions that they may not have had the opportunity to answer for the fullness of our analysis and our future reports.
Bonne idée, Monsieur le
Good idea. Minister? Yes, okay, thank you. Ms. Bendayan, I have a question for the clerk. Has an invitation been sent out to witnesses for next week? We adopted a motion last meeting which involved oh, yeah, no, this is exactly what we were going to be discussing now, Ms. Bendayan. If there's nothing else, Mr. Motz, before we excuse the minister.
OK, alors, Monsieur le ministre.
Minister, thank you. Ladies and gentlemen, officials, thank you for being here as well. I anticipate your being prepared to come back, Minister, anytime you're ready. Thank you.
Effectivement.
Indeed. As to next Tuesday's meeting, we have to make some decisions here. Do we want to hear from witnesses, or were there still motions that were suspended? We could take part of a meeting for, internal business, or do we want to go ahead with the witnesses? Mr. Chairman, my suggestion was to the effect that we provide clear instructions to the clerk to already start witness meetings. We planned 4 meetings with specific witnesses based on the motion passed at the last meeting. And a few weeks ago, we also passed a motion to call 2 additional ministers to appear, call for them to appear. Minister Blair, I think that would be the 4th witness. If I'm looking at our agenda here, we have 5 or 6 witness meetings that we have to schedule over the next few weeks, and we don't have much time left before the end of the session. Yes, on that point, correct me if I'm wrong, I think May 3rd we would do this again. In other words, this committee business. But really, it's up to the committee to decide. I'm not going to decide this myself. Of course, we have to hear from witnesses. Yes, there are motions that have been suspended. There is one motion that you've amended, and Mr. Motz presented it for the tabling of documents. If we want the government or anyone else to table the documents, we shouldn't wait till the end of June, because it might be worthwhile discussing that matter, whether we pass it or not, but we should do that quickly. With the witnesses here before us, I think we could ask them for their documents directly. I think it would be much quicker to do so. In fact, I'll admit that time is running out and we have work to do. And taking the time of this committee to discuss motions, etc., we've done that many times. Let's get to business, Mr. Chair.
The notion of continuing with the witnesses that we've agreed to. It's clear that with tonight, we had a very substantive 3-hour meeting. I'd rather continue with that than debating motions that don't shed much light.
Monsieur Mott.
Mr. Motz.
Thankfully, I will respectfully disagree with both Ms. Bendayan and Senator Harder. We do have committee business in front of us. it is beholding on this committee to finish that committee business. I propose that we have half of our meeting next week. We don't have any list of witnesses that are ready to go next week that I'm aware of. I suggest that we have half of our meeting next week to finish off committee business, and that we have the other half for a witness, whoever that might be, and be available. I think it's important that, given the time that the various motions might take to actually come to fruition, and whether we get agreement by this particular committee next week to deal with specific ones, it might take some response or some time to get those things squared away from a document release perspective or from other witnesses, and so I think we need to at least have some conversation and allow ourselves to do that. At the end of the day, we're going to have witnesses and witnesses and witnesses, and we have to have, I believe it's next week. Is it next week that our witness list has to be in, or is it by the end of this week? Last Friday. What, our first today. Right. So our first list of witnesses preliminarily has to be in today, and I think you'll see that it's a pretty extensive list. So we need to get at witnesses, but we also need to finish committee business.
J'ai Monsieur.
Mr. Green. Mr. Varani after.
Thank you, Mr. Chair. I just wanted to note, tonight is any indication on the reluctance of the government to provide this committee, which I believe was charged, we were sworn in, with information that would be pertinent to the testimony of future witnesses. Unfortunately, I think that we're in a corner where we're going to have a call the question at this committee at some particular future point in time to see if it is the will of this committee that we're going to work towards the transparency and accountability of this process, which includes the disclosure of documents. We had just in the last exchange here where the minister made it very clear that while it is true in other cases he could provide charter compliance information, he was not compelled to do that based on legislation. Well, as a committee, we have the power under lots of jurisprudence to demand for documents from this government. And I'm interested in those documents. I'm interested in getting to the facts of the matter. We've heard lots of reference to the facts, Mr. Chair, but yet we've yet to see them in plain sight, whether it's in an in-camera scenario or not. But I would argue that at some point in time we're going to have to deal with the motion that's at hand, which is to have a disclosure of documents that be necessary for the fullness of our future investigations.
À ce stade-ci, Monsieur.
At this point, I'll be giving you the floor, Mr. Varani, but a point of information. The clerk is advising me that what can be done for the next meeting is to have half the meeting on committee business, and then have a minister appear for the other half of the meeting. So that might be a way of proceeding. But again, I'm just saying this for your information. We will continue the debate unless there was anything else. Mr. Clark? To invite a minister of one or the other minister. We are not sure if these ministers will be available, but we can invite them. If not, there's future business and also the work of the analysts. It's up to the committee to decide what it wants to do. Mr. Varani.
I appreciate what the clerk is just indicating, but I just would reiterate that it troubled me something that Mr. Mott said, because he said he didn't know what witnesses we had to call. But we have a motion that we passed just prior to Easter, and I know that's 3 weeks ago, but I remember there were suggestions made. I moved the motion, and then suggestions were made to improve it, and I thought it was improved. But we had a motion that says that officials from the Department of Public Safety, the PPSC, Sergeant-at-Arms, Department of Finance, and the Department of Justice, and from the RCMP, CSIS, CBSA, and FinTrack be invited to appear before this committee on 4 dates chosen by committee members to discuss measures invoked on February 14th under the Emergencies Act for a period of 3 hours each. We went through some turmoil to get to that language that we agreed upon, and I guess what the clerk is looking for is for those dates to be chosen by the committee members. So with all due respect, I would actually propose a motion that we move to hear witnesses at the meeting on May the 2nd, if my dates are correct, and that those witnesses include all of the people that I just named be invited, and we'll see who is available. And we use all 3 hours, not une demi-rencontre, a full rencontre. Sorry for the Anglicism, but a full meeting to have those witnesses, because this was 3 hours. It was tiring, but it was good. And I think we should continue doing tiring but good work, because there's a lot to get through. Merci. So I would move that motion, ask that we vote on that motion.
Monsieur Virani, juste.
Mr. Virani, just to clarify things, which of the motions are you saying provides for the names of these? I know we said we've discussed it, but I can't recall which one. I can't recall the name of the motion, but I wrote myself a note here. I have some changes that I wrote myself here.
OK, donc,
Okay, so you are proposing the people that you've named for next week? Should we have a debate on a motion of this nature? The motion was passed. Mr. Virani is proposing that we invite some people to testify on May 3rd. Is that correct? That's what I understood from what you were saying, Mr. Virani?
Moving that we invite some of those witnesses to appear on May 3rd.
Yeah, I was asking that we invite all of them, and we see who is available.
And schedule for the next one.
And if some are available for the next week, then we schedule them for next week. And if there's spillover to the following week, May the 10th, I guess it is, then we continue to schedule. I believe that was the purpose of passing the motion. And Monsieur Le Greffier, I think you were just waiting to hear about which dates. So my proposal would be that we just continue with next week and the following week to hear witnesses.
Just to be clear, this is motion number 16, motion 17, stating that the Deputy Prime Minister, Minister of Finance, no, 17 is representatives, it's not the ministers. You were referring to ministers, or did I misunderstand? Madam Bendayan was referring to ministers. I was talking about representatives. Okay, so officials from the department in motion 17. Okay. Mr. Green.
Just, when the motion was passed, we didn't have specificity on the dates. And what I just caution the committee on is that, given that these motions have already been put, at any time, members of this committee, even with witnesses present, can move their motion at their slot. And what I don't want this committee to do is delve into a scenario when we have the politics of the committee interfere with the testimony of the actual witnesses. And so in that caution, I would suggest that by setting aside time for committee business, we wouldn't run into a scenario that might interfere with the testimony of ministers or witnesses at hand, because it is well within our rights as committee members at any point in time that we have the floor to move the motion. So rather than get into a scenario, and I'm contemplating myself being at that chair at some point in time where that might be the case, I would ask that we do contemplate a set aside to have those things that might not interfere or impede on the testimony of the witnesses that we've selected. So I just wanted to put that out there.
Madame Bendayan, oui.
Ms. Bendayan. Yes, in response to my colleague, Mr. Green, if it is the will of the majority of members of this committee to spend time debating motions, I would propose that we add another meeting to our agenda per week to do that, because honestly, everyone here was referring to the importance of moving ahead quickly, effectively, and in actual fact, that's not what I'm seeing, Mr. Chairman. I'm seeing that some members of this committee seem to want to postpone to I don't know when the important work that we need to do in order to ask questions of witnesses in order to come to some findings. There is a meeting next Tuesday. The debate is about whether we're looking at motions for the production of documents or hearing witnesses. There's a motion on the table from my colleague, Mr. Virani, where he refers to scheduling the next meetings for witness meetings for the tabling of documents. Or no, I propose we have a separate meeting to discuss documents. Mr. Nakvi.
I just want to add, we've already have motions passed here that has determined that there are 2 ministers at the least and various officials from very important agencies that we want to hear from. And at some point, we need to give instructions to our clerks to start scheduling all these people. It's not going to happen overnight. And we've actually, in the motion, have said for other witnesses, 4 weeks. So I think it's only reasonable, given the important work that we have to do, and we saw today a lot of heavy lifting was done, that we continue with this process and at the least start scheduling the people that we have agreed to. That includes 2 more ministers and witnesses from very important agencies that have been listed in the motion that Mr. Virani read. Thank you.
Monsieur.
Mr. Motz.
Thank you, Chair. I find it interesting that there's a offhanded accusation that some members of this committee want to push off witness testimony. We're here to hear witness testimony, but we also have some rules and parameters around the motions that are set here about how we're going to do business that haven't been resolved yet, and we need to resolve them. And we can still hear witnesses, and we need to hear witnesses, but to suggest that we take even a half a committee meeting to deal with some of the motions and deal with them and then move on, I think is a little irresponsible as a committee. That we just want to get at committee, but we have no structure around what we're going to do with some of this stuff, and what we're asking government to give us, as Mr. Green indicated, we already know what the government's position is on sharing the information that they relied upon to invoke the act. And there has been numerous of us around this table who suggest that we need that information for us to make an informed decision. So, I mean, you look at the motion, even 16, 17 that are here. There's a, Mr. Nakvi, you talk about the officials. These officials are not going to come all in one day. They were at least 4 days. So, I mean, there's probably maybe even 5 or 6 days, to have one agency per hour and a half would be reasonable. Because, as we found out today, you really can't get a whole lot of information asked if you have various agencies that have totally different areas of responsibility that we want to get information from. So I say let's be responsible and prudent to the responsibilities we have as a committee. Let's set half a meeting aside, and let's move on to witnesses after that.
Il y a Monsieur Brock.
Mr. Brock is on the list, but I wanted to also make a comment, if you'll allow me. I don't know. I just want to mention this. As far as I'm concerned, I would like us to solve the issue of the motions that, whether they be passed or not, I'll live with that, but I need to know what to do here, because the ministers are saying that, some ministers are saying they cannot produce documents. I would like to ask the question of the legal counsel for the commission, but that person has not yet been appointed. We hear that you need an independent legal counsel, and at the same time there's an amendment or counter-proposal saying that should be the responsibility of the clerk of the House. Okay, but I have a question. Can I compel the minister? Can the committee compel the minister to produce opinions that he claims he has, to complete his testimony with documents that he's mentioning in his response? To my mind, he should. I don't have a legal counsel to turn to find out if there is one, then we need to adopt the motions that have been set aside. Let's say these motions are not passed, there's no legal counsel, then I'll manage on my end. I'll find that. I'll get a lawyer to testify, and I'll ask the question of this lawyer. But you can understand that these are things that need to be done. Of course, I would love to hear from witnesses, many witnesses, and in fact over the entire summer if required. But I think we need to plan our agenda. Mr. Mott's motions on legal expertise, the production of documents, the counter-proposal from Madame Bendayan, all of this is important. I think, in my view, this has to be settled before we can continue our work peacefully, knowing where we're headed. I just wanted to share my view. We need to address these motions, whether it be done in an hour and a half or not. I mean, I don't think it has to take that long, but it has to be done.
Monsieur Brock.
Mr. Brock.
Thank you, Mr. Chair. In light of your comments, your intervention, I have nothing further to add. Thank you.
J'ai pas compris. C'est fini? OK. Vous me dites la sénatrice Boniface.
You're saying Senator Boniface, I think, wanted to speak.
Yeah, I was just going to suggest we call the question. We're only speaking as of tonight on this motion for next week.
Alors, ça va pour tout le monde?
Is that all right for everyone? Mr. Clerk, will you call the question on the motion? Madame Bendayan's question. Sorry, Mr. Varani's. As to us hearing next week from... Oh.
We need to hear the motion, please.
Ah ouais. Oui, M. Green. Ouais, mais c'est un petit peu délicat, là.
What's happening?
Oui.
Point of order. Senator Harder has suggested we have quorum. We can proceed with the vote. That is so disrespectful to members of this committee. We're entitled to a comfort break, and that's where I believe my colleague, Mr. Green, is, who's now entering the room.
OK, alors, la question ne se pose plus. Merci, M. Brock. Tout le monde est là.
All right, that's settled, Mr. Thank you, Mr. Brock. Clerk, can you read the motion for it to be clear?
Okay. Yeah, for the benefit of members of the committee, Mr. Varani moved that on May 3rd, the committee hear witnesses from the list that was adopted earlier of grouped witnesses for 3 hours. So to hear witnesses for 3 hours from the group.
Which witnesses?
Well, Mr. Varani left it open.
Non, c'était la liste.
Okay, so Mr. Varani was recommending motion 17, Mr. Clerk. I'll read it. You go ahead, you read it.
My understanding is that Mr. Varani suggests that the meeting on May 3rd be devoted to hearing the witnesses that are available from the following list: the RCMP, CSIS, CBSA, Department of Public Safety, Department of Finance, Department of Justice, FinTrack, as well as PPS, the Sergeant at Arms, and the Usher of the Black Rod.
So how many? I mean, it's a great amendment, but I mean, or a great motion, but how many are we going to call? And is it just for that meeting? Yeah. You know, that's what we have to figure out. Is it just for next Tuesday? No. And then are we doing like 3 of them? Are we doing 2 of them?
That's a buffet.
That's what we have to. Yeah, it's a buffet. Yeah, so we have to. If we have to, advise the clerk, whoever's available. There could be 5 of them available. That's not appropriate. We need 1 or 2, or 1 per hour and a half.
The motion was for 4 dates for 3 hours each. So that's roughly, I believe we'd talked about this, how we would potentially group them, and it was something like 2 or 3 per grouping. In fact, I have written down here, now that I look at it, Justice, RCMP, and CSIS be grouped as 1, Finance and FinTrack be grouped as another, Department of Public Safety and CBSA be grouped as a 3rd, and PPSC, Sergeant at Arms, and Gentleman Usher of the Black Rod be grouped as the 4th. So those were the 4 groupings that we discussed.
And depending on availability.
And depending on the availability, whichever group is available on May the 3rd, we proceed with that group. Do you need me to repeat that? Okay. So the groupings were Justice, the RCMP, and CSIS. That's 1 group. The second grouping was the Department of Finance and FinTrack. The 3rd group was the Department of Public Safety and CBSA. And the fourth group was the PPSC, the Sergeant at Arms, and the Gentleman Usher of the Black Rod. I'm glad I get to say that twice. And if you could please bring the Black Rod, we'd all be very impressed.
Doesn't that have some kind of significance?
Bit of levity late on a Tuesday.
Does that make us
So the proposal is to start scheduling all of them, to be frank, Monsieur Le Greffier, and start with whoever is available on May the 3rd.
The business. It's part of it. We're just going to keep having witnesses and just keep pushing off committee business? Is that what the Liberals' plan is?
anytime you want, and that's going to be the mess with
Yeah, exactly. Because they will. The motion's still before the committee. My motion.
OK, so
So my understanding, if I may, the motion that Mr. Varani moves that on May 3rd, we invite one of the four groupings that were identified in the previous motion, and we devote that meeting to hear witnesses for 3 hours on one of those groups, whichever is available. You okay pour la question? My colleague will start for the Senate.
I'll begin. The Honourable Senator Boniface. L'Honorable Sénatrice Boniface a voté oui. The Honourable Senator Campbell. L'Honorable Senator Campbell a voté oui. L'Honorable Senator Carignan CP. The Honourable Senator Carignan CP votes no. The Honourable Senator Harder CP. L'Honorable Senator Harder vote oui.
Maintenant, pour les députés de la Chambre, Monsieur Fortin.
Non.
Mr. Green. Ms. Bendayan.
Oui.
Mr. Nakvi.
Oui.
Mr. Varani.
Oui.
Mr. Brock.
Je vote contre.
Mr. Mott.
No.
The result is yeas poll 6, nays contre 5.
Alors, la motion est adoptée.
The motion is passed. So that is what will be done for next Tuesday. That said, Madam Analyst, the analyst is asking whether we still want a work plan for next Tuesday, because that had been asked of the analysts for next week. There's been no change of plan. We still want that work plan. Do we have additional instructions for the analysts to that effect?
Ouais.
Yep.
That down the road too?
You need an hour and a half to decide on.
Oh, we still have motions, Rachel. We still have motions.
And we're discussing those things at the moment while we had the full 3 hours of witnesses. Monsieur le Président, j'aurais.
Mr. Chair, I have a comment about something you said earlier. And it is simply to say that the law clerk, who is available to all of us as members of Parliament, is available to provide legal advice to members of our committee, just like members of any committee. So we don't need to pass a motion, adopt a motion to designate a specific counsel for our committee to provide, to ask for legal advice from that particular legal counsel, law clerk, and parliamentary counsel. I'm sorry, Stephanie, is that your name? We will need a work plan. Are you in a position, do you have enough information to provide us with something? Microphone, please.
C'est beau.
All right, fine. So we had up until today to table our witness lists. From what I gather, actually, it's... I mean, are there lists of witnesses that have been provided? Or some of us perhaps would like to do this but haven't yet?
Ouais.
Okay, that's fine, says the chair. Thank you, everyone. Meeting is adjourned.
Thank you.